Good afternoon. Welcome to the Appellate Division First Department. We have oral arguments for today, March 19. We have 8 hours of argument time requested. So please, I'm going to ask that you ask only for the time that you actually need in order to get out the salient points of your arguments. Please keep in mind that we are familiar with your briefs. We are familiar with your arguments as well. People v. George Jones. 525, Unzan v. Everest Scaffolding. Did you wish any time on rebuttal, appellant? 1 minute? 515. Matter of TB children. Matter submitted. Valerio v. Perez. Three. Interbar Fabricators v. CB Contracting. 525. Massaro v. Manfredi Auto Central. 4 and 2 and 3. People v. Deshaun Wright. 525. Quoshang International v. Bryant Park Funding. 525. Sanchez Presentes v. City of New York. 525. Maddox v. 106-108 Convent BCR.
4 and 2 for appellant, please, Your Honor.
4 and 2 and 4. Matter of GA Children. So we have ACS. Four and two, and 4. People v. Tyrese Minter. That matter is submitted. Sweeney v. Beck. Sweeney settled? Okay, we didn't receive anything that Sweeney has settled, but the matter is submitted then. Thank you. Lardieri v. Site 6 DSA. You represent whom? Gilbert. Peoples, okay. 5 and 1, 5 and 2, 4 and, I'm sorry, you represent Pace? So it's NYU, okay, Pace is separate. How much are you requesting? Let me see it and add up. 5 and 1, 5 and 2, 4 and 3. Zurich American Insurance v. 56 and Park.
Appellant CJI 4 and 2, please.
4, 2 and 4. NV Figueroa, that matter is submitted. People v. Devontae Gibson. That matter is submitted. T-Mobile USA v. Broadcom, Inc. Certainly. How much time are you requesting? Where are you from? Chicago. 5, 2 and 5. That's it, right? Thank you. So before we get started, I just want to say we have an intern from Fordham Law School. Yes, first year. Not the guy in the suit. He's one of our court attorneys who has long graduated from law school, like I can talk. But we have an intern from Fordham Law School. He's first year at Fordham Law School. So please, attorneys, can you be on your best behavior so he actually wants to go to his second year in law school? Appreciate it. First case for argument, People v. George Jones. Whenever you're ready.
Thank you, Your Honor. Whitney Elliott of the Legal Aid Society for the appellant George Jones. I wanted to start with a few points about the merits of our challenge to the amendment to the weapon possession count in this case. First, the original count was defective.
So were you in receipt of the people's submission this afternoon or this
Yes,
morning?
I was, Your Honor.
Yeah. And so how do you reply to those, to their, the cases that they have submitted?
So that goes to the question of remedy for the defect in the amended count. And I want to say a number of different things on that point. So first, this is not a People versus Burwell situation where the baseline is that the defendant faces the accusatory instrument on remand. This situation is governed by CPL 210.20 subdivision 4, where the baseline is dismissal, and dismissal is a bar to further prosecution. It's the prosecution that has to request from the court, and the court has discretion to grant them leave to represent. But absent such an application, the dismissal of the indictment bars further prosecution. There are several cases, People versus Sanger from the Court of Appeals, Hardware, Bloom, where there's just an outright dismissal without granting leave to represent. But in terms of the court's discretion, and because this is not a Burwell situation, the test is not the no penological purpose test or the minor crime test. It's just at the court's discretion. And there's no presumption in favor of granting leave to represent.
Well, Sanger talked about notice, is that correct? Sanger spoke about notice, is that correct? Notice to the defendant as to what the charges are or the allegations are?
That's true, but the notice itself is limited to the contents of the particular account, not based on all documents that the defendant had access to.
Well, it's also, well, to some extent, aren't you also looking at what other documents or whether the bill of particulars or the voluntary disclosure form, whether or not they also would expand or give greater knowledge to the defendant as to exactly what the allegations are?
With respect, I disagree, Your Honor. In terms of the adequacy of the count, this goes to the merits, not the remedy. But the adequacy of the count looks to, they can make a sufficient count by referring to the underlying cross-reference statute by section number or title, or by including charging language in the specific count that tracks that. It's not about documents external to the count. It is permissive as between one of those two things, but those are the ways that the prosecution can ensure a facially adequate count in an indictment. I want to get back to the remedy point, but there are a number of points about the case itself and about Mr. Jones himself about why permission to represent is not appropriate. First, and this goes to our point one, it's at best ambiguous about whether the statute even covers Mr. Jones's conduct here. Second, this is a bumped up misdemeanor. There was no intent, there was no injuries caused or even intent to cause any. And the prosecution had two chances to fix this below before the case even went to trial. When the indictment first came back, and then they perceived the defect in it before the cases even started a hearing. The trial prosecutor opted to take his chances, even though it's recommended, as we point in our reply brief, that if there is a potential issue, the prudent course is to resubmit the case or get a superseding indictment. The trial prosecutor declined. In terms of Mr. Jones, I just want to emphasize he's completed his sentence. He's a 71-year-old man. The 730 reports talked about how he had observable facial and hand tremors when he's speaking. So his mother died when he was 5 or 6 years old. His father beat him with extension cords. He went into foster care at age 9. He had a history of chronic homelessness and psychiatric hospitalizations. This is a situation, an individual who deserves a break under the circumstances of this case, not that the prosecution gets a third chance to fix the defect in the indictment here.
Thank you. You do have time on rebuttal.
Okay, thank you.
Good afternoon, Your Honors. Hunter Barron for the people. I do want to start with the indictment.
I thought one of the issues, or the main issue, was whether or not the court providently exercised its discretion in allowing the amendment of the indictment.
Yes, of course, Your
I
Honor.
thought that was the issue.
Yes, of course, Your Honor. I think the underlying assumption behind all of this is that the court is not at leave to amend an indictment that is already jurisdictionally
Right.
defective. So ultimately, the threshold question is whether the indictment was jurisdictionally defective to begin with, the unamended indictment. And so the question is whether the allegations, which were possessed a dangerous weapon, were sufficient in order to meet jurisdictional standards. And we read the statutory provisions that defendant is citing as really just companions to the jurisdictional standard, putting them into the statute.
So in order for the defendant to know exactly what he is being charged with,
Yes.
a simple reading of the indictment would you say give him sufficient notice as to what it is that he's facing? Or does he need to go back and look at other things in the penal law to sort of like figure out what it is that I have to defend against?
It would be the latter, Your Honor, but I think more precisely, it's the combination of the indictment with the other documents that were provided in this case.
VDF and the voluntary disclosure form in the bill of particulars.
And the complaint, yes,
And the
which we,
complaint.
yes,
So
yes.
we're talking about basically the second count of the indictment. Is that correct?
That's correct.
So the second count of the indictment says committed the crime of criminal possession of a weapon in the third degree as follows. In the county of New York, on or about April 29, 2017, possessed a dangerous weapon. What does that mean? I mean, normally there's going to be to wit whatever it was, especially in this case since it was identified as first we had it as a sharp object, then we have it as a drywall saw, and then you wanted to amend it to from possess a dangerous weapon to possess a dangerous instrument, to wit, a sharp object with intent to use unlawfully against another?
That's right, Your Honor.
So we start out with possessed a dangerous weapon, and then somehow we get to possessed a dangerous instrument, to wit, a sharp object with intent to use the same unlawfully against another. So how, again, does this give notice to the defendant as to exactly what the allegations are, what he is accused of, what crime or actions he's accused of committing?
Yes, of course, Your Honor. I think it really is the indictment in combination with the bill of particulars, the complaint, which lay out the exact allegations against the defendant, which are that he allegedly stole some items, a security guard approached him, and he drew a knife and threatened to stab them.
Well, did he draw the knife or did he just point to the knife?
I think he pulled it out.
Did he pull it out?
Yes. And, you know, Your Honor, I will add that this is not the best practice drafted indictment to begin
It's
with.
really one of
I
the
won't,
worst. It's one of the worst drafted indictments I've ever seen.
Yeah, I
I
understand
just
that,
don't
Your
see
Honor.
how you get from, as I stated, from dangerous instrument or dangerous weapon to with intent to use unlawfully again, possess a dangerous weapon to possess a dangerous instrument to wit a sharp object with intent to use the same unlawfully against another.
Sure. I think the case law establishes that that the indictment and the bill of particulars are really being read together, and that's the importance of the bill of particulars. Defendant in this case requested a bill of particulars, and our response was that the voluntary disclosure form, the indictment, and the complaint provided all the particulars that defendant required. There was no, and the allegations in the complaint were perfectly consistent with just that subdivision 2 of a 26501, which is the
What was the reason
intent.
for the delay in moving to amend the indictment or not refiling? What was that?
Sure. It's not totally clear from the record, Your Honor. I think the transcript implies that a new prosecutor had come on the case and realized that there was this drafting error in the indictment, and then sought to amend it accordingly. It's possible there were other things, but it's not really reflected in the record. Your Honors, before my time is up, I did want to address the issue of remedy. So I understand that defendant would like this case affirmed if Your Honors choose to. If Your Honors do not dismiss it with prejudice, and that would be the inappropriate remedy here. We cite the Hernandez case, which found that there was no basis for dismissing with prejudice with no leave to present, and the defense has not provided a basis here. This was a very serious crime, unjust the crime defendant was convicted of. It's a Class D felony. There was a threat of violence against a security guard, and it would also be important for terms of future exposure as a second felony offender. That would be the kind of penological purpose at weight here, even though defendant has indeed completed a sentence.
Thank you.
Thank you.
So just a few quick points on rebuttal. It's affirmative grant of a dismissal with prejudice is not what we're asking for. It's the prosecution that has to convince this court to use its discretion to grant it leave to represent the case. Under the statute, the baseline is dismissal that bars further prosecution. It's the prosecution that's making an application, that's asking for leniency from the court by asking the court to exercise its discretion to grant it permission to leave to represent. In terms of what the issue here, Justice Weber, I just want to, with respect, I don't think it's whether the court properly exercised its discretion to amend the indictment. There was no discretion to amend the indictment. 200.70 sub 2A and B bar amendments if the count fails to charge or state an offense, or if there are legally insufficient factual allegations. That statute clearly bars any amendment, regardless of any lack of prejudice to the defense, and regardless of any consistency with the prosecution's theory
Is
before.
that because it is jurisdictional at that point?
Pardon me, Your Honor?
Is it because it's jurisdictionally defective at that point?
You could think of it in those terms, or you could think of it in terms of the language of the statute fails to charge or state an offense or legally insufficient factual allegations. And the four corners rule governs here, even the forgiving Cohen standard that in under some crimes that don't, for example, cross-reference other provisions, that just citing the statute is enough. Even that inquiry is limiting itself to the four corners of the count at issue. There's really no authority for looking to documents external to the account to make out the factual allegations for each element of the crime. Just want, I guess, a couple brief points about our sufficiency and weight of the evidence. The against another component of this refers to physical contact between objects. That's the common meaning of against. That's the meaning that the court attributed to the term in Carter and Brown. The court expressly declined to read into the statute an additional requirement of an intent to threaten. That those cases hold that an intent to threaten is not a part of the statute. The statute here does not refer to an intent to use or
Thank you
threaten
very to
use.
much. Thank you both. Unzane v. Everest Scaffolding. Yes, you may proceed.
Stephen Gustafson of McCormick and Prairie for defendants NW 100 and LSL Construction. May it please the court, this summary judgment motion was an instance of basically usurping the jury function because of conflicting accounts that plaintiff himself had
What were the
given.
conflicting accounts?
Well, first of all, the bent spreaders, the court below inferred that the spreaders had bent, causing the fall, and
Well, didn't the plaintiff testify that he heard a noise and then the ladder failed in some way and then he fell? And in response to that, was there anything to specifically rebut that, or other than speculation?
And please, let's be clear, the noise was not like some outside noise. The noise was from the ladder, that the ladder made a noise, wobbled, and then he fell.
well, that's what respondent argues, that the plaintiff heard the sound of the spreaders bending. What he said at the record 500, page 534, line 24, was that the ladder had a little sound that was like a scratch, like you were scratching the floor. 524, those two sites, scratching the floor when you're on a ladder atop a floor. So that in no way, what he said other times, he said he'd fallen on top of the ladder, breaking the ladder and his ribs, 470, inferring that the bending was his weight. He said he broke both, and the ladder had not been bent before the accident. He said he was pushing a screw gun
Let me
again.
ask you a question. Is it enough for you to point out defects, these purported defects in the plaintiff's testimony, or do you have to come up with some sort of affirmative evidence on your behalf to raise that issue of fact?
Well, when the competing versions are both versions from plaintiffs, then that's where the Semper Twiggy case comes in, that you have issues with inconsistencies, thus calling into question overall credibility, and the circumstances underlying those questions created triable issue.
See, that's what I'm not understanding. What is the overall credibility issue? He was on the ladder because he had to, he was doing the sheetrock or whatever above the window. You could not have a scaffold because of the layout. You had to use the ladder. The ladder was wobbly. He fell from the ladder. What are the issues?
Well, he had the,
What's not controverted?
he
Did you
said
come
he
forth?
said the ladder moved, but this is in the context when he was pushing the screw gun into the wall to screw something in. So certainly it could be inferred that he pushed himself away from the wall in some fashion, as opposed to the ladder just spontaneously moving.
But again, did you come forth, this is your motion? It was plaintiff's motion. Did you come forth with anything to rebut the plaintiff's recitation as to what occurred?
Rebut which recitation? He had conflicting recitations.
His
Which one?
testimony basically was that he fell from a loose ladder as he was putting sheetrock above a window in an area where there's no other safety device. The ladder wobbled, he fell.
The ladder wobbled. In other contexts, he said it moved, but again, he was pressing
Wobbled and
into the
moved
wall.
wobbled and moved aren't it all contradictory, are they? Wobbling is
Moving
one
is
form
fine,
of
but the
moving.
ladder's going to move if somebody's standing on it and pressing against the wall with a screw gun.
So in order for the ladder not to move, someone has to be spotting it, holding it. And was he working with someone that was holding the ladder, and that person was?
He was working with someone who was sent home, and the trial court characterized it as he was encouraged to go on alone. And what the record, page 543 and 44, he said he could finish by himself when asked. And the court interpreted that as he had been encouraged. And all of these, facts could be interpreted in different ways. And,
Counsel?
One from column A was chosen instead of one from
Counsel,
column.
isn't it true that all the plaintiff has to make at a prima facie is to show that it was an inadequate safety device, and then the burden shifts to the defendant? Here we know the ladder either moved or wobbled, and it was inadequate whether or not someone was holding it or not. That is uncontroverted. What testimony do you have to controvert the testimony that it either wobbled or, according to you, moved?
Well, we cited the Semper Tergi case in which we had inconsistent accounts by plaintiff, which even after he had established a prima facie case, raised issues of credibility. And by credibility, not saying anything sinister, somebody's out to, not tell the truth, but you can be uncredible on an issue if you don't have a vantage point, if you don't remember it correctly. And he said different things. He said he fell on the ladder and broke it, and then he said he heard a sound, and then everybody inferred that hearing a sound meant the sound of the spreader's bending. And if
Thank
there's
you.
a
You have
spreader's
time.
bending sound, it's not
Counsel, you have
scratching.
time on rebuttal. Thank you.
Thank you.
Good afternoon. Gregory Generelli for the respondent. There's no dispute as to how this incident occurred. The plaintiff was on a ladder that wobbled, he fell.
What about your friend's argument that there are inherent inconsistencies in your client's testimony as to exactly what occurred?
As to exactly what occurred, he was consistent that as he's screwing in the soffit, the ladder wobbles, shifts, he hears a sound, and he falls. Now, whether he heard a sound or he didn't hear a sound, it doesn't matter because the ladder
If the
wobbled and he
ladder,
fell.
if the ladder shifts because of the force that he's generating, is that still this kind of case where summary judgment is entitled, or are ladders not supposed to shift?
Well, ladders aren't supposed to shift, but there's even a case from this department back in 2021, Dimming Wu versus 34 17th Street, that says vibrations from the work that you're doing are insufficient to raise an issue. There's still summary judgment is appropriate under 240 in that situation.
In the event that the work he was doing would cause vibrations or something else, there are certainly would you say there are other safety devices that could be employed to protect the worker from the fall that might occur otherwise?
Well, there weren't in this case. In this
That's what I'm
case,
saying.
they
Are
could
there
have-
safety devices that could have been employed that would have protected the worker under these
Sure,
circumstances?
they could have used a Baker scaffold or a scaffold
I
of
thought they
some sort
said
if
that-
there was there.
I thought they said you couldn't because the area was so small.
Well, they couldn't because they didn't have any on site, number one, and I think the project super, who was also the site safety manager, said, I don't like to use them, I don't think they're as safe.
So the only other option would have been to have someone holding the ladder.
That was an option, had there been someone there.
Well, there was
They
someone
haven't-
there in the morning, right? And that person, which I didn't see in the record exactly why that person left or was told to leave.
The Rocco, who was the foreman for the
Right.
job, for plaintiff's employer, he sent workers on their way or to do other things, and specifically asked plaintiff to finish this if he could on his own. Plaintiff said, sure, I'll do it. I want the work. So he did it. The ladder wobbled and it fell. So that in and of itself is enough for plaintiff to be awarded summary judgment. The lower court proper determined as much. He couldn't be the sole proximate cause of the accident because they failed to show or provide adequate safety devices or equipment. There is nothing in this record that warrants a reversal of this decision on 240. It is extremely clear. I think there's 7 or 8 decisions from this court with very similar factual situations in the last 2 months, 3 in the last week, 1 this morning. All support plaintiff being, the summary judgment being affirmed for the plaintiff in this case. And I think it's so clear, I think the 241-6 argument is academic, but if you want me to address anything with respect to that, I'm happy to do it.
No, thank you.
Thank you.
Your Honor, the difference between these different versions is encapsulated in plaintiff, what he said at 543:44 was he could finish by himself. When asked, could you finish by yourself? And that's a subtle difference from some guy encouraging it or some guy telling him to. It didn't say you can do it, can't you? He just said, can you do it?
So then, are you saying that he assumed the risk of working?
No, the question is under Sempertegi, it says if somebody's credibility is called into question and there are inconsistent accounts they give of the accident, as were the inconsistencies here between did the bending of the spreaders cause the fall or did him falling on top of the spreaders cause the bend, which he testified to both of them. At one point, he, page 539 of the record, cited by the trial court, he think the spreaders bent either as I was falling, which agrees with his broke summation, or is what caused, or he doesn't know. So those 3 options. And that's fine if the gentleman wasn't sure about those 3 things, but it's not a credible witness for whatever reason, and that's the Sempertegi point, is that you don't want to usurp the jury's ability to decide whether somebody, an interested witness is you know, if they're telling the truth, if there are any problems, the phrase "if any," that's the trier of fact.
Both.
Thank you.
Valerio V. Perez. Yes.
Good afternoon, Good afternoon, Your Honor. This is Sean Hutchinson from Cipriani and Warner for defendants appellants Perez, Piona Transport, and PTL Intermodal. May it please the court. The court below improperly granted plaintiff's summary judgment
Counsel, what is the non-negligent explanation for having collided with a vehicle in front?
The rear-ended the vehicle.
So, according to the defendant's affidavit, both-
Whose affidavit?
the defendant's
Is
affidavit,
that Mr. Perez's affidavit?
yes,
And what language was that affidavit in?
that affidavit was in English, Your Honor.
Was it English?
Well, the affidavit that was submitted was in English, Your Honor.
was
Excuse me,
in-
excuse me,
no.
it was in Spanish with an English translation.
Was there a certified transcript from Spanish to English?
No, there was not, Your Honor.
So then is it admissible?
Our
I think the
contention,
answer is no.
our contention is that in opposition to a premature summary judgment motion, that the court should consider that affidavit.
Really?
Just like the court
And that's
below
based
did.
on what?
Well, that's based on
No,
contrasting.
I meant what law, what cases? What cases stand for that proposition?
Well, it's more about contrasting the cases that plaintiff relies on, Your Honor.
No, what about cases within this department that speak to what you just said?
I cannot point to any particular case, Your Honor, that supports that position.
So in the absence of that affidavit, which it seems to me we can't consider because it has no affidavit of translation, why should we decide for your client?
Your Honor, plaintiff's motion was premature.
No, in
Counsel,
the, ab-
I'm sorry.
go ahead.
Even if we were to look at the affidavit submitted by your client, it references a sudden stop and stop and go traffic. What does our case law say about that and distances that need to be maintained when you're behind a vehicle?
Understood, Your Honor. Well, in this case, according to the defendant's affidavit, it's not just a sudden stop. It's also that both vehicles were changing lanes into the new exit lane.
What does our law say about unsafe lane changes?
Your Honor, both vehicles were changing lanes at the same time.
And
How does that matter?
there is no-
I'm not really sure how that matters. They're on the Deegan, they're both going over to the exit lane. He is in back of, obviously, the vehicle that he ultimately struck. So what does our case law state in terms of keeping a safe distance in driving and also in making lane changes?
Well, Your Honor, in the act of making a lane change, it's not necessary that you're able to anticipate that the other person in front of you is also making a lane change.
But do you not always have to keep a safe distance?
You do, Your Honor, but when you're changing lanes into a lane that you see is open, and then the other person also goes into that lane, that's a different situation.
Really? Thank you.
Good afternoon, Lori Parkman for Plaintiff Respondent. The affidavit, as you've said, is inadmissible not only for the lack of translation, but it was also in New Jersey with no certificate of conformity, which they did not even address in their reply brief. But Your Honors are correct that even if we disregard that the affidavit is completely inadmissible and that it contradicts the statements that Perez made at the scene to the police, the affidavit establishes the defendant's liability.
would we need more discovery?
No, the cases are clear that in rear-end vehicle collision cases, affidavits from the drivers are sufficient because the defendant driver is has all of the information that he needs to say what happened in the accident. And that's, I can cite to the Ahmad case from 2023, as well as many others. But he's in possession of the information and he could set forth, if you consider his affidavit, which you shouldn't, but if you consider it, he set forth his version, but his version, he's liable. He claims that the plaintiff stopped in stop-and-go traffic. But as you've suggested, the case law is clear that a driver has an obligation to leave sufficient room from the car in front to provide for foreseeable stops. And that's, once again, the Ahmed case from 2023 is directly on point, where that involved a rear-end collision in a construction zone, and the defendant claimed that the plaintiff suddenly stopped and in front of him, and this court said it was insufficient to raise an issue of fact because he failed to show that he left sufficient distance, or that the plaintiff's repeated braking was unforeseeable given the traffic conditions, that it was a construction zone, and that he did not show it was reasonable to think that traffic would continue unimpeded. Here, Perez, by his own affidavit, says it was stop-and-go traffic, which by its very nature makes a stop foreseeable.
Did he say at the scene that both vehicles were merging into the same lane?
No, he did not. At the scene, he told police the exact same thing that plaintiff's affidavit says, that she was in the middle lane, he was in the left lane, he went to merge into the middle lane and rear-ended the back driver's side of her car.
So the only one merging, the only one changing lanes was the defendant?
according to plaintiff and according to Perez at the scene. But as Your Honor said, it doesn't even matter if they were both merging. She was in front of him. There's no claim that she veered out from a lane far away, which would be the Hernandez case, where she crossed 2 lanes of traffic before stopping. Here, she was in front of him, and the damage is to the driver's side car. So she was further to the right than he was. So there can't be a claim that he didn't know she would be merging in front of him. She was right in front of him. So for all these reasons, the order should be affirmed. He didn't raise an issue of fact as to his liability or as to comparative negligence. And discovery is not necessary in rear-end collisions where they can submit affidavits. Thank you.
Thank you both. Interbar Fabricators, BCB Contracting. Yes.
Good afternoon, Your Honors, and may it please the Court, Christopher Bletch from Picard and Abramson for the appellant E.E. Cruz and Company. I want to focus on 2 errors that the motion court made. It assumed that the quantities that were delivered to the site equated to the quantities that were installed.
So how would we, how would one know what the quantity was that was delivered to the site? Wasn't there a document? Wasn't there inspection? Wasn't there some type of agreement between the parties at the time that the steel was delivered?
Yes, but it's important to differentiate the agreement between CB Contracting, who was the installer, and Interrebar, who was the supplier. So Interrebar would deliver to the site to CB, who would accept. E.E. Cruz, who was the foundation subcontractor, who was responsible for paying CB, didn't take the deliveries. And there's testimony that they did not get proof of what was delivered. There's no tickets that equate to the total amount that CBC is.
So they were never there when the steel was being delivered?
I wouldn't say never, but not for every occasion. But in any event, the quantities delivered don't equate to the quantities that are installed, and Cruz is only obligated to pay CBC for the quantities that are installed. So equating the total that was delivered with what was installed was a clear error in the interpretation of the contract.
Did the subcontract say that they would be paid for the actual quantities delivered or installed? Like, where is
Installed.
that in the contract?
Installed. The term is bent and installed.
And installed.
Yes, it's in the subcontract. I could get the site. But it's
So
not
what, after it was delivered, who was in charge of installing?
CB Contracting.
The same contractor that was delivering?
Interrebar was delivering and CB was installing.
Right, so, but right now, the debt is to CBC.
Correct.
Because they're the ones that are saying, we received, we installed, and therefore we're billing and we haven't been paid.
Correct. They were paid based on 8.4 million pounds, and they claim that the total installed was 8.8. There's a difference in quantities that each of the parties say was installed, and that creates a question of fact. Certainly every case about unit price contracting where one party is saying that the quantity that the claimant is saying they installed was different creates a question of fact.
Now, before they installed, wasn't their work inspected? And
yes.
Sort of like the quantity more or less
Yes.
Verified?
Verified to the extent that it was supposed to match up with the shop drawings, and this is why the shop drawings are important, because the shop drawings show the quantities that were supposed to be installed based on the design. So the 8.4 equates to what was shown on the shop drawings, and they didn't submit shop drawings that show a greater quantity was required, and there were no contemporaneous records kept by CB or E.E. Cruz for a greater quantity than what they were already paid for.
So you only based the amount that was installed on the shop drawings, or would anyone be able to look at it and say, okay, yeah, this amount of rebar is there?
Once the concrete is poured on top of it, you can't go back and determine the exact quantity.
Right, but
That's why it's important to do it contemporaneously.
But before they poured, Cruz was supposed to have inspected and authorized, right? Okay, this is the right amount, and
Correct.
now we can pour because It looks as if it's what we're paying for.
That's right, and that was done to the extent that it was consistent with what was shown in the shop drawings. That was the contract document that showed the quantity that was supposed to be installed, so they verified that that quantity was being installed, it was consistent with the shop drawings, and that's why the amount that was paid to them was consistent with the quantity from the shop drawings. So yes, that confirmation was done at the time, and it's consistent with the amount that they were paid.
So what else would CBC need to produce in order to get paid for the balance that they say they delivered but haven't been paid for?
Understood. Either updated shop drawings that show a greater quantity than what was in the drawings that were approved, or as-built drawings, which says, okay, the shop drawings show the plan, here's my as-built, which shows something different than what was in the plan was actually installed, and that could have been approved contemporaneously.
Was there a requirement in the subcontract for those as-built drawings?
Yes.
Did CBC state that they never installed anything without prior authorization, and they only installed what they were authorized to install?
That's right, and what the authorization shows is quantities up to 8.3 or 8.4 million pounds, not 8.8. So we agree that they were authorized to install what they did install, but the dispute is about what the quantity of that installation was. And the records that EE Cruz has and that we worked with CBC on show up to 8.4 million pounds, not the 8.8 that they're claiming.
Thank you.
Thank you.
Good afternoon. May it please the court. My name is Joshua Deal, and I'm here on behalf of Respondent CB Contracting.
So you're saying that you delivered 8.8 million pounds of rebar, and do your documents actually add up to that?
Yes, Your Honor. And here's the way this works. So the shop drawings themselves do not include the quantities of rebar. They're details of the connection points for where rebar being bent will be installed. The quantity of rebar is a complex calculation using hard math, basically calculus, based on density requirements that are stated by the engineer of record in the structural drawings. From there, when these shop drawings are produced and approved, what the detailer then does is they take that approved drawing, they run it through a program called a fencing program. That program does the hard math, figures out the lengths, types, and quantities of rebar that would be necessary to meet the density requirements.
So once those shop drawings and this calculation that you're discussing right now is done, is there something else in the contract that requires then a second set of an as-built?
No, Your Honor. So what the subcontract requires is that we provide all documents, warranties, shop drawings, as-built, and a litany of other documents that are as required by the contract documents for our scope of work. Nowhere else in the subcontract does it specifically require in the scope of work the production of as-built drawings. There's nothing in EE Cruz's trade contract above that includes a specific requirement of as-built for this scope of work. In fact, there's only one mention of as-built, and that's in the final payment clause, along with another litany of things that may be required by the contract documents.
So how do you explain the discrepancy?
Well, I don't believe there is a discrepancy, Your Honor, because what the evidence shows is that when these approved drawings were run through the fencing program, that was used to develop a release for that shop drawing. That release was then used to fabricate the steel called for and is then reflected on the bill of lading for the delivery for that set of rebar. It's all tagged and recorded in that bill of lading and is verified on site when delivered. We then would install that material, and you have multiple layers of inspectors and engineers coming through to verify that it's done in accordance with those approved shop drawings.
And these multiple layers of engineers and inspectors, are they your engineers and inspectors, or are they Cruz's engineers and inspectors?
It's not my clients. It's EE Cruz's engineers, the JV, who was the general contractor, their engineers. The engineer of record for the project would often review these, and there's a special inspector required by the building code to be hired by the owner to do those inspections as well.
Were there situations or times when the bill of lading was not provided on delivery, and how should we look at that?
There's some testimony that there may have been a few instances where they were not contemporaneously provided. None of the witnesses could identify any particular time when that happened or missing bills of lading. And the witness for E.E. Cruz actually conceded in his deposition that if one had not been provided contemporaneously, they would send an email to my client and get it shortly thereafter. So there's not a real pattern of missing documentation here. Everything was above board and done according to the standard procedures for these deliveries and installs.
So in essence, they're also arguing that you're only entitled to payment on 8.3 million pounds of rebar because that's the amount that they agreed to with the JV. So, you know, what do you say to that?
Well, they had a lump sum contract with the JV. We had a requirements contract. So our contract says that we get paid based on amounts actually installed. When we actually installed this material, we're invoicing, getting paid late. There was a brewing dispute between the JV and Cruz about various change orders, including the steel. They did their own calculations without involving CB contracting. They decided on a particular amount to settle those claims. However, they haven't even put into evidence in the record on summary judgment those actual calculations, what they were based off of, what data they relied upon. There's no admissible evidence to even back up that 8.4 million or in some cases 8.1 million claimed in their papers.
Thank you.
Thank you.
The one point that I wanted to make in rebuttal was that the Cruz did ask CB Contracting for the shop drawings as this process was going along so that it could advocate for a greater quantity to the JV. The JV had calculated a lower number, approximately 7.7 million. Cruz's calculation was 8.1 million, something like that. And using the information that was provided by CB Contracting, they presented the shop drawings and the analysis that they did have and got the JV to agree to a greater number of 8.3 million. So they were certainly asking for this backup, and that was the greatest quantity that was backed up. Was no more than 8.3 million. They were paid 8.4 million to advance the project and keep the work going, and that's why the calculations don't match. And according to the Cruz calculations, CB was overpaid based on the quantities that were established.
Thank you.
Thank you.
Massaro v. Manfredi Auto Central.
May it please the court, Kenneth Gorman for the plaintiff appellant. At the outset, these defendants were not out-of-possession landlords as a matter of law. I mean, they built this rooftop parking lot, which leaked for 20 years, which they tried to repair at least a dozen times. And after leasing the building, the ceiling continued to leak while Manfredi continued to make use of the building when the ceiling collapsed on the plaintiffs. But regardless, since the defendants did not include the lease with their motion—
How did they maintain control over the premises?
Well, Mr. Manfredi testified at page 403 of the record that the only entities that had control of the roof and the ceiling was Manfredi, CEM, and the tenants. That's it. No one else had access to that roof. But
Had access to the roof, but who was actually responsible for it? Who was actually using it?
the tenants. The tenants were using it, but Manfredi was the owner, and he was there every other month. He used that building as if it was owned. He went to the building, he retrieved his files, he used a desk.
Right, so because there were periodic visits to the roof, and I think there was, as you might have just said, there was a filing cabinet of files that was stored there. Does that mean that they're not out of possession?
Well, in Gronsky versus County of Monroe, the Court of Appeals stated that an owner remains in presumptive control until relinquishment is found, and that courts must examine the lease agreement and course of conduct, including the owner's ability to access the premises.
Okay, so what about the lease agreement then because I thought the lease agreement stated that the tenant shall maintain the premises, including the roof, exterior walls, concrete floor slabs, et cetera.
True. That's 6.2. 6.3 of the lease and the defendant's course of conduct established that they were not out of possession landlords. Section 6.3 of the lease clearly states that the defendants were responsible for repairing any condition that they were negligent for creating or any act that they did. And Freddie admitted that CEM and the tenant had access to or control of the roof of the building in 2009 at page 403 of the record. And Waring versus Sunrise Yonkers, this court held that the owner failed to establish that it was an out-of-possession landlord where it had access to the facility and access to the tenant's books and records. Here, the defendant's actual knowledge of the specific dangerous condition and retained control of the roof and ceiling makes the plaintiff's case far stronger than Gronsky and Waring. And under 6.3, the defendants had a duty to repair the ceiling. 6.3 states that the landlord shall make repairs due to its acts or negligence, and even after the tenant took possession. This was not temporal. After Manfredi built the rooftop parking lot, the ceiling leaked whenever it rained.
Who built the that rooftop area?
Manfredi, the defendants.
And who used it? Did your clients use it?
Yes, they did use it. But the lease clearly states that if Manfredi created the condition, it had to rectify it. And since Manfredi built the rooftop parking lot and attempted to repair it at least a dozen times before leasing the building, under section 6.3, he was obligated to repair this condition.
But
Counsel, are you still pressing your claim that we should dismiss because defendants didn't submit the lease, even though you corrected that alleged defect by submitting it yourselves?
Yes, I am. They can't meet that burden. We submitted the lease because we moved for summary judgment on our own terms. Had they if they only.
Shouldn't we decide, once you corrected it, why shouldn't we decide it on the papers that are in front of us?
Because a movement has to make their case prima facie when moving for summary judgment. They can't rely on the plaintiff's evidence. But
Counsel, did you make that argument below?
no, it's not preserved. But in Navarro's versus Vorna Realty, which we cited page 4 to 5 of our reply brief, this court held that a question of whether a defendant makes its initial burden for summary judgment is a question of law that can be considered for the first time on appeal.
Thank you. You have time on rebuttal.
Good afternoon. May it please the court. My name is Diane Toner, and I'm here for defendants' respondents. The first point I would like to make is that even though plaintiffs are claiming that Manfredi had access and control of the roof, I'd like to point specifically to the testimony that he's relying on. On page 403 of the record, Nikki Manfredi was questioned. Other than Manfredi Auto Central and its managing company, CEM Management, and the tenant, was anyone else given access to or control of the roof and ceiling at 111 Quintard Street in 2019? In response to this question, he answered, "Not that I know of. I can't testify to that." And that is the testimony that's being cited to say that Manfredi had access and control of the roof. Just this statement that he did not know, and he could not testify to that. So clearly here, the landlord did not have possession or control of the premises. Mr. Manfredi would occasionally notify the tenant that he had to come by and see some records, and he would be allowed into the building, and he would be given a desk, he would look at some files, and then he would leave.
Was he ever not permitted to go, or was the course of conduct that he could always come when he wanted to?
There's no evidence that he could come anytime he wanted to. His testimony was that he only came approximately once every 2 months, I think, and that he would always notify in advance, and he would come to look at the files that he maintained, and that's it. So he wasn't coming to inspect, he wasn't coming to repair, he wasn't coming to oversee any operations, and he only came with permission of the tenant. So we maintain that this is an out-of-possession landlord. This is a triple net lease that clearly gave the responsibility of maintenance, repair of the entire premises, including the roof specifically, to the tenant. Also, the accident occurred 4 years into this lease, and the tenant had had complete control and access and the sole possession of the premises during that time. So any condition that arose was solely the responsible of the tenant to repair. I'd also like to point out that
Who repaired the leaks during those 4 years?
Nicky Manfredi's testimony is that he repaired the lease when his company had possession of the premises. So if the leak was repaired during that time, it would have been by the tenant. There's no evidence that Manfredi was coming in to do any repairs during that time.
So during the 4-year period of time, Manfredi did not repair any leaks?
There's no evidence that he repaired any leaks at all during that time. No, it was just during his possession, which was prior to July 2015. Also, I'd like to say that there is no direct connection here between the ceiling tiles falling and this testimony that there were leaks. So we don't have any engineer's report, we don't have an expert affidavit to really make a connection between the leaks that were occurring and the tiles that fell.
The tiles were wet, weren't they?
I believe they were wet, but I'm just saying that it's assumed that the
Did
tiles.
anybody pour water on them from above?
I don't think there was water.
I don't think, so it must have been a leak then.
It's likely it was a leak, yes, but I'm just saying that there's no evidence that clearly makes a connection to the rooftop or a design defect or some condition that was created.
Do you need an expert for that?
I
Get
think
hit with a wet tile because there was a leak in the roof and the tile is wet and it strikes me. Do I need an expert to say, well, you know, the tile fell because of a leak?
I would think that you need an expert to say that it is because the way the rooftop was built in the 1990s that the ceiling tiles fell in 2019. Yes, I think you need someone to make that connection.
Okay.
Thank you.
Thank you.
Manfredi testified at page 377 of the record that the rooftop parking lot began to leak after he built it.
Can you answer who fixed any leaking condition between the 4 years from 2015 when your client took possession and?
The record isn't clear.
It's not clear.
It's not clear, but the leak started.
Is there any evidence that anyone did it other than your client?
Excuse me?
Is there any evidence that anyone other than your client made any repairs to the roof during that 4-year period?
Not during the 4-year period, but before conveying the premises, Manfredi tried to repair the condition at least 12 times. He
No, I understand,
testified
but
to that.
once you took possession, there's no evidence that anybody else did repairs.
That's correct, but under section 6.3, Manfredi was responsible for correcting the condition that he created.
So your position is that because they built the roof, they're responsible for it forever?
No, because they built the roof, and right after they built the roof, it started to leak. Manfredi testifies to that. And they attempted
Isn't
to.
this a triple net lease where the repair of the roof is in your client's responsibility?
Section 6.3, I always go back to that.
How about 6.2?
6.2, under 6.2, yes, but under 6.3, no. Section 6.3.
How does 6.3 relieve you of responsibility when we have a specific provision, 6.2, which puts that in your responsibility and duties as the tenant?
Well, circumstantial evidence clearly shows that Manfredi created the condition.
Is there any
Manfredi's
testimony after the Manfredi gave up possession of the lease, of the premises and leased it to you, that it came and did any maintenance or repair to the roof?
No, he didn't. Manfredi did not, but he was obligated to under the lease agreement.
What was the circumstantial evidence that Manfredi created the condition? Because it leaked prior to your client taking possession?
Manfredi testified that after he built the parking lot, the roof began to, the ceiling began to leak because of water buildup on the rooftop parking lot.
Yes.
So building the rooftop parking lot, after he built it, that's when the leak happened. He tried to repair it at least a dozen times. He never was successful. He then leased it to the plaintiff's employer. He continued to go to the building. He used the building. He stored files at the building.
No, I understand all of that, but during this 5-year period or 4-year period, there are no leaks, there's no repairs being done by Manfredi or by your client?
They tried to repair it. They were unsuccessful.
Your client?
Donna D'Amico, I think, testified that repairs were tried to, they did try to repair it, but they weren't able to. It
But again,
continued
that's
to
your
leak.
client, not Manfredi, right?
I don't know who tried. It might have been a third party. It's not clear who tried, who repaired that. Who attempted to repair the roof during that 4-year period. The record is not clear. No one has any testimony.
Thank you both. People v. Deshaun Wright. Yes, whenever you're ready.
Good afternoon, Your Honors. Aviva Galfbert for Mr. Deshaun Wright. Mr. Wright was denied a fair trial when the prosecution told the jury repeatedly that it should find him guilty of second-degree burglary because he had not supplied an innocent explanation for his presence in the apartments. This court has recognized, as in Collins and Gamble, that the comment on a lack of an explanation is a burden shift in itself. And here, the use of the term innocent did special violence to the presumption of innocence. It also collapsed the elements of second-degree burglary, and it imposed an impossible standard.
Counsel, did you make that argument below?
Your Honor, this was not preserved below, but as the court has held in Ortiz, for instance, and other cases, the court may reach summation misconduct in its interest of justice power, especially where that conduct is pervasive, as it was here.
So isn't there also case law that says that if you don't object, it shows it's not prejudicial to your defendant?
Your Honor, it was prejudicial here, as we can see from the fact that there was
Why wasn't there an objection if it was prejudicial?
I can't speak to that, Your Honor, but you know, this court still has the interest of justice power to review this, and we can see that it was prejudicial, especially when we compare it to the first count where there was an acquittal, and we look at the other compounding factors here, including the denigration of the defense.
Were the remarks made in response to defendant's arguments in any way? And if so, how would we look at that?
Yes, Your Honor. Thank you for asking. So first, it was in response to the arguments the defense, of course, Mr. Wright did not put on an affirmative case, but defense counsel did state in summation that Mr. Wright was there, you know, delivering a package, that he had not been there with the intent to commit a crime, and that was what the prosecution denigrated.
This is the second incident, right? This is the incident where he is in the young lady's apartment.
Exactly. This is Ms. Rowell's apartment. Exactly, Your Honor. He was acquitted on the first count.
Yes.
And so the prosecution was denigrating the defense that the defense did offer in its case, and also in the prosecution.
Did the statements make any sense as to the defendant being in someone else's apartment, allegedly delivering a package to that individual?
Well, Your Honor, that was for the jury to decide, but
And can't we assume that the jury rejected that story?
Well, Your Honor, we have to look at here the evidence, and the evidence here was equivocal at best. And there's
But don't we also have to consider?
How is it equivocal?
Well, for instance, Your Honor, there was a drawer with jewelry in it that was open. If Mr. Wright had been there with the intent to steal something, he would have taken the jewelry.
Well, no, it's
But it also
being there, that is what we're talking about right now.
Yes, Your Honor.
So he says he's there to deliver a package to another apartment, and he needs to go through this
Right, he said
complainant's
he needed
apartment.
a passway through her apartment to get to this other apartment where there's no passway from her apartment to the other apartment. He's delivering a package to her, to the drawers where she has her underwear and other possessions.
Well, Your Honor, he may have gotten confused. He may have been there compulsively, and he may have
Thought he was delivering a package to her drawers?
Well,
To the
Your Hon-
dresser drawer?
Your Honor, the consciousness of guilt is not really dispositive here because he was guilty of trespass. And so the fact that he told a story that doesn't necessarily make sense,
Well,
he did not
again-
have to prove that he was there for an innocent reason, and he was there illegally. We agree with that.
But it's going beyond not an innocent reason. His reasoning made so little sense that it underscores what he was actually doing there.
And the prosecution was allowed to comment on that as implausible, but what it wasn't allowed to do was denigrate the defense repeatedly, calling it ridiculous a dozen times.
It was ridiculous.
Your Honor, it's...
I mean, it was ridiculous. I mean, what he stated was in many ways ridiculous. So I'm not understanding why. I mean, the prosecutor used words such as unbelievable, ridiculous, absurd, fantastical. I mean, you're stating that these are insults, but his statement in terms of his delivering a package to another individual, and now he's in this individual's apartment because there's a passway, and there's no passway, but yet the drawers to her dresser are open. Why is that not ridiculous?
Well, Your Honor, here, First of all, the word ridiculous is especially, I mean, especially when it's repeated so many times, it went beyond fair comment. It was
Well, then,
lampooning
where
him.
was the objection?
And there should have been an objection, Your Honor. We agree.
And
But
if we're talking about the larcenous intent as someone goes into an apartment, right? And the story that the jury hears is that this person said that they were delivering a package through their apartment, which, I mean, I don't know if that ever happens, you know, but the jury heard this version of it and they rejected it. What's wrong with that?
Well, Your Honor, I see my red light is on, but if I may respond quickly.
Please.
Thank you. So here it's the combination of all of these remarks, the fact that the burden was shifted onto Mr. Wright, and then the denigration made it more likely that the jury would conclude that he had failed to meet a burden that was not his to begin with.
Because the prosecutor referred to his explanation as something that is nonsensical, doesn't make it.
Not because the prosecution did that, but because over and over and over the prosecution ridiculed him and made these ad hominem remarks.
Thank you.
Thank you, Your Honors.
May it please the court, my name is Patricia Curran and I represent the people on this appeal.
How should we look at the prosecutor using such inflammatory language? I mean, do we condone that in our interpretation of the case law?
When you say inflammatory
I mean,
language,
it's
Your Honor.
ridiculous, it's things like that, fantastic.
Well, Your Honor, this court has held that it is totally appropriate for a prosecutor to comment on the improbability of a defense. Now here, as Your Honors have noted, this defendant, when he was found by the three victims, if you count the second man in the first apartment, he gave what even Judge Weber has said are ridiculous excuses.
Don't quote me on anything.
I'm sorry, Your Honor, I will not. I will not. But he told the individuals in the first apartment that he had been chased by robbers, and that's why he ran up the stairs of the adjoining
Which they
building.
actually believed him, which again to me was fantastical. That they would allow this man in their apartment and have a conversation with him for over 20 minutes because he stated that he had been chased. That I thought was absurd and fantastical.
In many
I
ways.
believe he
Your
went through a window too, right?
And then he goes to a window and he goes on the roof of the other building and he's waving to them, saying, yeah, you know, they're still following me.
Your Honor,
That I could not believe.
Your Honor, I would agree
But
that
it was
there.
more so the victims in that case than him that I
there are
thought
many-
were.
I would agree there are many
absurd.
fantastical pieces of the two burglaries at issue here. But, and excuse me, he was not convicted of burglary for the first one, only
No.
criminal trespass. But the defense attorney's centerpiece of his summation was focused on the explanations the defendant gave in the two apartments, claiming, and the only issue at trial was whether the defendant had intent to commit a crime. And he used these explanations in both apartments to support his argument that the defendant had just accidentally happened to be in those apartments. So the ADA obviously had to refute.
But was there a point where he just went beyond? I mean, it wasn't really necessary for him to continue with these statements?
You mean in terms of what he was saying about?
Yeah, exactly. Yes, in terms of.
Your Honor, in my
absurd,
humble opinion,
fantastical.
I don't think so. I mean, of course, you can find any of this error, if you find it to be error, to be harmless because the evidence was so incredibly
Well, that's the
strong.
other issue, whether it does in fact constitute
But
harmless error. But your friend's argument is that this somehow shifted the burden to the defendant.
Well, Your Honor, the prosecutor never said that this defendant had to present any evidence of any kind or to present any evidence that he was innocent or show how he's innocent. All he said was that in these two apartments, and he said it in a variety of ways, the defendant gave these explanations because he had to come up with an innocent explanation of why the victims found him standing in their apartments. That is not the same thing as saying that the defendant had to come forward and present evidence at trial. In addition, the prosecutor said during his summation that he had the burden of proof, and of course, as Your Honors know, the judge charged the jury at the end that the prosecutor always bore the burden, and the jurors are presumed to have followed that. Now, I noted that my adversary did not mention any of the other points in the brief. If you have any questions, I see my time is almost up. Or any questions about the summation, I'd be glad to answer them. Seeing none, thank you very much.
Thank you.
Your Honors, briefly, first, I'd like to point the court to its decision last month in Sync AT. I know Your Honor was on the panel, where the court, citing the Court of Appeals in Bakke, said that where the evidence is purely circumstantial, as in this case, it's that much more important that this court satisfy itself that the inference of guilt is the only one that can fairly and reasonably be drawn from the facts, and that the evidence excludes beyond a reasonable doubt every reasonable hypothesis of innocence, because
But I think you've gotten some sense that some of us at least are concerned that there is no other explanation that makes any sense, because his own statements made so little sense that that was all we were left with.
again, Your Honor, he may not have had a good reason for being there. His being there was illegal. We don't condone it. It was criminal trespass, but that doesn't mean he intended to commit a crime.
So that's
The
your
record
point, that it's
shows-
criminal trespass, there's no burglary,
Right.
there was no larcenous intent.
Exactly.
He
He
got
didn't
turned
do
around
anything-
when he was delivering this package
Well-
in someone else's apartment.
Your Honor, he did not have to have an innocent reason. The record
But that was what was
establishes-
testified to, that's what the jury heard.
Right, but the record also establishes.
And the jury
that-
was probably maybe judge the credibility of the witness who did testify, the people's witness,
Well,
and judge the testimony that came through there.
and also they may have been influenced by the rank hearsay that was admitted. And just to speak to that briefly, the prosecution utterly failed to meet its foundational burden. This was
Was this
in
the
no
excited
way-
utterance by
Yes,
her?
it was
She's on
not-
the phone with her father yelling that this man is in her apartment.
Excuse me, Your Honor.
She's on the phone with him, and all of a sudden she turns around and she sees him standing in her apartment.
Yes, Your Honor, and that was not the hearsay statement that was admitted. The hearsay
After
statement was
he
the
actually,
subsequent-
after she was able to get him to leave the apartment, then she calls 911. It was within minutes of his leaving the apartment that she calls 911.
Well, there are two things to focus on here: her activities in the interim and the nature of the call itself. So first, she's on the call with her parents, with her father, and then her mother as well. And then she speaks with a neighbor who sweeps the apartment from the call. So all of these would have gone to.
That was within 1 minute, right?
Yeah, I mean,
But it's not measured in units of the clock, as the court said.
Why does it matter if she testified and was subject to cross-examination? Why? It's harmless, at any rate. She testified to this.
Yes, and her testimony really offered nothing factually except that it allowed the jury to hear her affect on the day of and to hear her distress, and the prosecutor focused on that in summation, the difference between the complainant's responses, and her emotion was a major factor in this case in distinguishing the first count on which there was an acquittal from the second on which there was a conviction.
thank you so
Your
much.
Honors.
Kwashong International v. Bryant Park Funding.
Good afternoon, Your Honors. David Satnick on behalf of the appellant Bryant Park Funding. The motion court improperly granted summary judgment on the respondent's claim for specific performance of 2 multi-million-dollar condominium units. And
She had every expectation of having put into her name, being given title to after her initial investment, which was supposed to be which that was supposed to lead to,
her expectation is governed by the terms of the agreement that she signed.
which included, among other things, being advised when the condo conversion plan was approved by the Attorney General's office, of which she was never advised in a timely way.
She claims she was never advised.
What proof do you have that she was advised?
I don't have proof because I haven't had an opportunity to take any discovery. Certainly, she had the means within her disposal.
That wasn't in the contract. She was supposed to have been advised by it, of
She
it.
was supposed to be advised, but she certainly visited the building. She saw units were being sold. She had to have known, putting aside the fact that she was
That's not exactly being
represented.
given notice, is it, counsel?
What's that?
That's not the same as being given notice that she was contractually entitled to, correct?
But if she knew that the
Counsel, she was not given notice pursuant
I
to the
don't know that.
contract.
I don't know that. I haven't had a chance to take any discovery of either.
Counsel, isn't it true that Mrs. Ding was provided year after year information that it's her apartment? They were doing build-outs, they were doing all types of customization of the apartment. She was led to believe by Mastriani.
Not Mastriani, Your Honor, HFZ.
Okay, whoever it was.
Not my client, not Mr. Mastriani.
So clearly, let me finish, please. Clearly, there was in the record that they refer to the apartment as Ms. Ding's apartment. And all that would waive any requirements that there be notice, because for all intents and purposes, they treated the apartment as Ms. Ding's.
They treated it as Ms. Ding on the expectation that the construction was going to be completed, that the third-party debt, including the $50 million of mezzanine financing from the EB5 investors that Ms. Ding brought into the deal, would be paid.
Didn't your client have actual knowledge of the prior notice of pendency?
No, Your Honor. No,
The
no,
record reflects
because the
otherwise.
notice of pendency,
Your client didn't know anything about the notice of pendency that was filed previously? And the
We're talking
litigation
about
that
against the
surrounded...
other units?
Let me finish.
Against units
And the litigation...
30B?
You're speaking over me. And the litigation that surrounded these apartments?
I think, did we have prior notice that she had made a claim against units 30A and 30B? I think we're charged with that notice, but those are not the units at issue here. We're talking about 31A and 31B.
But I thought that the 13th floor was not included, and therefore that would be the same unit as per the offering plan.
And that didn't develop until there was additional documentation that was submitted in the record of that proceeding. But the bottom line is here, the judge simply credited the course of dealing that you referred to, the expectation. And sure, if things had gone according to Doyle, if things had gone according to plan, and the building was complete, construction was complete, the financing would have been paid, and she would have had this right, which was she could revoke at any time prior to closing. She could exercise or convert. She never served, put aside that she didn't get notice, if we credit that. Let's excuse that. She didn't get notice. Put aside, question as to whether she knew anyway. What prevented her from sending her notice of intent to convert? Nothing.
She didn't, but on the other hand, she was continually asked to participate in the renovation process. It was always referred to as her apartment. What basis, why, given all of that, would she assume it was necessary to do that?
Because the agreement provided that she was required to give a notice to convert. The agreement also required her to provide a purchase and sale agreement with the terms to be negotiated. That never happened. So are we going to excuse the failure to give the notice to convert, excuse the purchase and sale agreement to be negotiated, and then now excuse the fact that the contract says the closing is to occur on the ladder to occur of the payment of the third-party debt, the $50 million that she was instrumental in placing? Are we to excuse that? Or the fact that there was no TCO for the building?
Thank you. You have time on rebuttal.
Good afternoon, Your Honors. May it please the Court, I'm Bradley Nash of Hoge, Newman, Regal, and Kenny, representing the plaintiff, respondent Kaohsiung International. This appeal turns on a single question.
So, counsel, why didn't she take any action to ask for conversion of the two units into her name, since she would have seen that other apartments in the building were being sold and so on?
Your Honor, for years, everyone involved in this transaction, that's Ms. Ding, that's HFC, the developer, and it's also Bryant Fark Funding, which was involved in this case from the very beginning, treated Ms. Ding as the owner of the units.
She was a sophisticated real estate investor. Surely she would have known that at some point she needed to have title. Why didn't she take any steps to get that?
So, Your Honor, it's undisputed that she did not submit the conversion notice. It's also undisputed that her duty under the contracts, if we want to be sticklers to the contracts, it's also undisputed that the event that would have triggered her obligation to serve the conversion notice, which is HFZ's obligation to serve a formal notice of the effectiveness of the offering plan, that also never happened. So for better or worse, none of the parties followed the procedures.
If it's HFZ who is supposed to give her notice of the conversion, why does Bryant Park suffer from that?
Pardon?
Why should Bryant Park suffer from the fact that HFZ didn't give her the notice of the conversion?
Because Bryant Park knew about this transaction from the very beginning, And they've waived, to the extent they have any ability to enforce HFZ's defenses. Remember, HFZ has defaulted. They're not here opposing a closing. To the extent Bryant Park Funding has any right, which we don't concede, to assert defenses that HFZ has waived. They waived them in real time during the transaction because they treated her for years as an owner, and they've waived them in this case because they've defaulted. To the extent Bryant Park Funding can even assert those defenses, they've also waived them because they too, for years, treated Ms. Ding as the owner. Remember, they transferred the funds that were used for the purchase price, and their lawyer wrote, "We're sending this money for the purchase of 2 condominium units." They were the ones, one of your honors mentioned the years of customized alterations that were made to the units. It was Bryant Park Funding that was communicating with HFZ on behalf of Ms. Ding. And it was Bryant Park Funding's principal, Mr. Mastroianni, who texted Ms. Ding in November 2020 and said,
How do you address the issue with the apartments numbering, one is 30 and versus 31,
Sure.
A and B?
Sure. So that's a very interesting issue because, and I think it's very illustrative of what's happened in this case. The letter agreements refer to the units by the floor designations that appear in the Department of Building records. So each floor is just numbered sequentially. The marketing plan for this building, and it's consistent, everyone will know from other, skips the 13th floor. So what happens is the 30th floor in the Department of Building records for marketing purposes becomes the 31st floor. That was very clear all along. But when Bryant Park Funding entered this litigation to seek to vacate the notices of pendency that had been filed, they strode into court very confidently. And what they were saying then was they weren't talking about the conditions in the contract not being satisfied and so on. That's a whack-a-mole that came up later. What they were saying initially was, you have no contractual right to the 31st floor. Look at this contract. It says units 30A and B. Now, we don't see that in their brief now because when confronted with the contemporaneous correspondence, when confronted with Mr. Mastroianni's own statement to Ms. Ding that it's a matter of semantics, the 31st floor is the same thing, so suddenly that argument disappears.
Can you address the argument regarding whether or not who's first in line, the notice of pendency versus the mortgage? There's all types of ambiguity when it was filed.
So the notices of pendency are a complete red herring. Notices of pendency are a statutory mechanism to establish constructive notice of a prior interest in the property. We don't need notices of pendency. You can completely forget them. Imagine we'd never filed a notice of pendency. The reason Bryant Park Funding's mortgage was properly voided by the motion court was because they had actual knowledge of Ms. Ding's prior interest. So the notices of pendency are
Did they have
non-issue.
actual knowledge of Ms. Ding's interest?
Pardon?
How did they acquire that actual knowledge?
Because they knew about this transaction from the very beginning. It was Bryant Park Funding's attorney who originally forwarded the letter agreements to Ms. Ding. It was Bryant Park Funding's attorney that transferred the $11.5 million
Because they had the
purchase
mezzanine
price.
loan as well?
Pardon?
Is that because they had the mezzanine loan as well?
And the mezzanine loan, of course, was in place, and everyone knew about it at that time as well.
Thank you.
Thank you.
What the record shows is that we knew that she had made an investment to acquire preferred membership interests that gave her an opportunity, subject to compliance with the requirements and the condition preceding, an opportunity to convert her units, which you could revoke at any time prior to closing.
But she only had to exercise that after she was given notice of the conversion, which never happened.
I don't know that's true, Your Honor. I
There's-
haven't had
Well,
any
let me say it
discovery.
differently. There's nothing in the record before us that
I
show,
agree.
excuse me,
I agree. I'm conceding it. I'm conceding, there's
Well,
nothing
see,
in
the
the
problem
record.
is, counsel, you don't know what you're conceding because you don't allow the justices
I'm
to
sorry.
ask the question.
My apologies.
So you could be conceding the entire case. So that's why it's really important to allow us to get out the questions to you, and then you can answer,
Your
and then you can concede whatever you want to concede, okay?
so are you conceding there's nothing in the record that shows that she was ever given notice that the conversion occurred?
I concede that because the record is incomplete.
I'm not asking you why. I asked you
Because
if
I
you
haven't
did.
had a
That's all
chance.
that I asked you, counsel.
Yes, thank you. And that's what I conceded early on. And it's because the record is incomplete. For the first time that we're seeing many of the documents upon which the respondent relies, the first time we see them, it is a motion for summary judgment that the court invited sui sponte while prohibiting us from taking discovery. Some of those documents are in Chinese. I don't speak Chinese. I don't know if anyone here speaks Chinese.
What would you be looking for in those documents?
We want to know, Your Honor, whether the Ms. Sting complied with her obligations under the agreement. Did she give a notice of conversion? If not, why? Did she send a proposed purchase and sale agreement with the terms to be negotiated? If not, why? Did she understand that her preferred membership interest, which gave her this opportunity to purchase, was at all times subject to the interest of the EB-5?
How would any of that change the court's determination?
Very simply, Your Honor. If indeed she understood it and the agreement and the document so provides that she understood that she could not acquire title until all the debt is paid, we're here with still the debt unpaid. She's not entitled to specific performance, let alone to vacate the project-saving mortgage that my client put in there to finish the very unit that she makes a claim to and to finish the building.
Thank you.
We need discovery.
Thank you so much.
Thank you.
Sanchez Presentes v. City of New York.
Good afternoon. May it please the court. Alexandra Alvarez for the appellant. The lower court was in error to deem the late notice of claim timely served. There's 3 reasons for this.
Counsel, this is an issue on which the motion judge has discretion, correct?
That's true.
And normally we defer to that discretion, correct?
That is correct, but in this case, the underlying court's decision states some facts that aren't correct. There's several things that were misstated. For instance, in this case, the lower court found that there was a reasonable excuse for the delay.
That's not a question of fact, that's an inference, not exactly a question of fact.
Well, it's an inference then, but there's...
You disagree with the inference the judge drew from the facts. That's not the same as getting the facts wrong.
Okay, they did get the facts wrong.
What facts did they get wrong?
Okay, in this case, the plaintiff says they were confused by the ambiguous tax records regarding the ownership of the property.
How do you know that that's wrong?
Page 39 and 40 of the record specifically state that the owner of the property was the dormitory authority in this case. But in this case, plaintiffs served the state of New York and the city university first. And they were told that the owner of the property
Who told them that?
The state told them in November, 4 months before they filed the notice of claim.
That's by providing the deeds to them, right?
That's
and they don't really explain what happened in those 4 months as to why they didn't do anything.
Correct. And the deed is explicit. It's a 50-year-old deed from 1972 that states the property was passed from the city to the dormitory authority. And I mean, nowadays it's fairly
How do we
easy to
balance
determine.
what you're saying with this issue of actual notice and the job incident report?
Okay, so I'm not claiming that DASNY was unaware that an accident happened, but the law is clear that it's not just having notice, you have to have sufficient notice of what actually happened.
Why wasn't that sufficient notice?
The incident report is missing a lot of details.
I was wondering if you'd mentioned that because that was drafted by your client.
That's true.
So why should we treat it as that they should be excused from knowing much about it because the incident report was inadequate when in fact it was a DASNY employee who wrote the inadequate incident report?
So that would create a slippery slope. This is 50E deals with municipal or public entities or corporations. basically, if we accept plaintiff's argument that a thorough report and investigation should be conducted for every single incident, this is going to, this is going to take tons of resources, time, and money.
Maybe the incident report is not taken for the purposes of later litigation. It's just taken to record what incident happened. Is that your position?
Correct, yeah. It was just done preliminarily. I mean, this is almost taking away from the onus, which is on the
Are
plaintiff.
there any situations where incident reports can be used to show actual knowledge? What's missing here?
I mean, there is case law from all the departments that say even having an incident report, specifically the case of Kumar versus Dasney, which is the same entity involved here, where it was a construction site accident. Dasney created a report stating that there was an incident where a laborer, his shoulder got hit by a 2x4, but the court said that that is not enough.
But the issue is whether or not you have actual knowledge of the essential facts, right?
Correct.
And so this incident report is probably not the best incident report because it does contain limited details. It does state well, first of all, it was completed within hours of the accident by your project manager, but it states the time, the place, the injured worker, and the nature and the general nature of the accident. So why would that not be sufficient?
It doesn't talk about his injuries. It doesn't talk about any kind of treatment he might have had. Again, there could be accidents all the time, but Dasney has no indication.
If you file a notice of claim, is that information that usually would be contained in a notice of claim?
They have
injury and the treatment that the claimant has?
Yes, as somebody who
received?
actually does a lot of, I actually do work for the city of New York as well.
Yeah, I
as
do too.
NYCHA.
I don't remember putting the exact injuries in the notice of claim. I mean, receiving a notice of claim. You would certainly put the how the person was injured, and you would put general information as to the injuries.
And it would also include some sort of negligence and what kind of assertions they're making about.
Right, but here we have again the injured worker and the general nature of the accident. So, in terms of notice, and I think we said in matter of Toro and Sokolowski, housing authority case, that is sufficient.
There is other case law that's said, from Pineda versus the city of New York from this department as well, that says there needs to be something more. It's got to have some sort of theory of liability as well.
I don't know about the theory of liability, but I think that goes back to my colleague's initial question or question to you, the fact that there is notice, and also more so, this is within the discretion of the motion court. And so we really can adhere to or accept to some extent the discretion and the findings of the motion court. But you have time on rebuttal.
Okay, thank you.
Good afternoon, Your Honors. Excuse me. Jay Breakstone for the plaintiff.
So why the delay from when you learned? I know, right? Why the delay? Was that going to be your question as well?
Yeah, what's going to be my question?
I didn't have a chance to button my jacket even, my goodness.
Is it buttoned?
Yes, it is.
So why the delay? Now, you know that from the state tells you who the correct entity is. Why is there that delay in filing a notice of claim?
Because they were trying to figure out who the proper parties were. And they didn't have the documents readily available to them. And this is just in the record.
On November 9th, 2023. And in your papers below and even in your brief here, you don't really explain that. It's kind of like you gloss over it by saying that, well, we didn't get oral confirmation until April 8th of 2024. But you had the deed to at least investigate.
Apparently there was massive confusion, and that's what the court below said.
But what was
When
the
the court
source of
looked at
the
it.
confusion? Once you had the deed in front of you, what's the
It
confusion?
obviously wasn't as simple as that.
Well, but why wasn't, there's no explanation as to why having a deed in front of them was not sufficient notice of who the correct defendant
There is also no explanation as to why.
But you're the one who has to explain it. So can you explain it now? Other than by just saying that
There was a confusion over the deeds. There was a confusion over the ownership of the property. There was a confusion over who was working on the property and for what reason, and for what purpose.
I'm still having trouble understanding. I've got a deed in front of me. It says this, Dasney is the owner.
It obviously, I'm sorry, Your Honor, I didn't mean to
How,
interrupt.
what confusion is caused by that deed? How does that deed
It
confuse
was,
the
ob-
person?
it was obviously not as simple as that.
What makes it less simple than that?
It's not in the record as to what makes it less simple. What is in the record, Your Honors, is the fact that this was very clever on the part of the defendant, on Dasney. They had an incident report that said very clearly on the report, Mr. Project Supervisor, who's filling out this report on behalf of Dasney and sending it into Dasney, don't leave any blanks, because if you do, we're going to send this report back to you to be filled out properly and appropriately. So this report is gotten by Dasney, and I think it is clear that they never sent it back to their project manager for the critical information that they would need to defend this claim. In their own words, the critical information they need to defend this claim. They sat on their project report calmly and sedately. And now they come back before the trial court and they say, you know what? We don't have any of this information. And the trial court calls the
I'm not
bluff.
understanding your argument that they sat on something. How were they to know that there was going to be a lawsuit? I mean, I know this is New York and, you know, this is what we do, but maybe this was one of the rare instances where there was not going to be a lawsuit. So I'm not understanding your argument, oh, well, you know, they sat on this.
Your Honor, in defense of New York, if I had somebody in East McKeesport, Pennsylvania, who was working on a truck and gets hit with girders and gets knocked off the truck and goes to the hospital, right? And how did they know he was so deadly injured? What about the workers' comp case, which they were aware of?
I understand what you're saying, but again, your argument is that they sat on this and that somehow they should hold some responsibility for not having the incident report more in depth or going back and getting additional information. But I don't know that really makes a difference in this instance where you did not file the notice of claim until months after you knew who the proper party was.
That's not exactly what I'm saying, Your Honor. What I am saying is that they can't take this position now on a late notice of claim case in which, what's the concept? Is there prejudice? Because if there's no prejudice to the defendant, then the late notice of claim is a fair thing, because we want litigation, we want matters cleared up as far as injured parties. But what happens?
Would they be able to investigate this claim at this point?
Excuse me?
Would they be able to investigate the claim?
Well, that's interesting, because the fact is they're no worse off than they were before. They control all the evidence. And the fact of the matter is they have all the parties available, and did have all the parties available all this time. So when we get down to the bottom line, and we always deal with this, where's the injury? Right? Who is put at a worse position here? Dasney had all the information before, still has the same information it had. Nothing in the record to indicate that it doesn't. It says, in fact, the claim of prejudice, if you see at the sort of end of their papers, is sort of amorphous.
Thank you.
Thank you, Ron.
I think by arguing that Dasney didn't conduct this complete investigation, we're getting away from the purpose of GML 50E. It's supposed to put defendants or possible parties on notice of a lawsuit. And now all of a sudden the burden is shifting to the respondent to do all
But
of this.
if something else already gave them notice, then why is it so important? Why is the notice of claim as important? Since they did have notice because of your client's own actions in filing and completing the incident report, albeit inadequately.
But the law doesn't just say notice, it says sufficient notice. It has, or efficient.
The only reason the notice was insufficient is because your client's employees didn't fill it out adequately.
That's correct, but is that supposed to happen with every single time that there's a claim against a public entity? I mean, there's been
Counsel,
incidents
can we
where.
address the prejudice issue? As my colleague just mentioned, this was a transitory incident where the plaintiff was standing on steel. It's no longer, obviously, you can't replicate that. So what's your prejudice?
Well, there are still witnesses who could have been interviewed, and Dasney is the project owner.
You knew at the time of the incident of this situation, and you could have gotten witnesses at that time. So you had actual knowledge of the accident. It doesn't say that you did anything in terms of an investigation as to who the witnesses is. How does it change your position in terms of prejudice?
Again, they didn't know a lawsuit was going to be filed. And I mean, there's several things that are wrong on that incident report, but how far and how deep are they supposed to go in terms of?
Under Newcomb, which is the new standard, the case law that has come out is that actual knowledge and prejudice are the main two elements, and there have been cases where even when there's not a good reasonable excuse, that the courts within the discretion would permit a late notice of claim. Isn't that true?
It's true to the extent that these factors are important, but I feel like none is specifically determinative. So
I believe that there's case law that says that the excuse is the one that we can overlook. Obviously, every element is important, but the real meat of the standard is actual knowledge.
But again, I think that we're getting away from the meaning of the statute because it's going to create a slippery slope, because then, well, you know, maybe we'll just file the notice of claim 10 days late or 20 days. I mean, it was 8 months late in this case. And not to get too deep into it, we still don't really have much discovery in this case. So.
Thank you. Thank you both. Maddox v. 106-108 Convent.
Good afternoon, Roger Sacker, Newman Ferrara, LLP. We represent the appellant. May it please the court. There's 4 questions here. The first one has to do with whether a counsel's affirmation can introduce exhibits. We solved that Tuesday. Gravy LIC Development, Justice Hagler was on that panel. It's cited to both Najiro Ordonez and to a Court of Appeals decision, Zuckerman v. City of New York, that says that my affirmation is sufficient to introduce things like the DHCR rent rolls. I see no reason to depart from that 2-day-old precedent. The next has to do with New York Guide to Evidence 10.11. Surprisingly, there is almost no case law on the New York Guide to Evidence, I think because it's fairly new. However, we've followed it to the letter. We have voluminous exhibits, number 1. The originals
They
must...
may be voluminous, but that doesn't make them necessarily adequate. You have lots of charts, but you didn't have the underlying documents on which the charts were based. So excuse me.
Sorry,
So the fact that they're voluminous doesn't mean that they're adequate. If, for example, they cite dates of leases and amounts of leases and there are no leases attached, then how do we know, or how does the motion court know that they're reliable? So I don't understand how you claim that it's adequate documentation.
Because that's what the rule says. The rule says the court then may order the offering party to produce the underlying originals in court. I don't have to do it unless the court tells me I have to do it. That's the last sentence in Rule 10.11.
But of course, that applies to motions for summary judgment, which you didn't make. You made a motion under CPLR 906 subdivision 1, which is not a basis for seeking a summary judgment of any kind. So you have a problem there too, don't you?
Well, I agree with you that I did not make a summary judgment motion. I definitely agree with you there.
But what relief did you think you were going to get under CPLR 906.1, which is not a vehicle for determination of an issue?
I was going to get, it is a vehicle for determination of an issue. It's an issue class. So I was determining the issue of whether or not the defendants had engaged in a methodical attempt to evade the rent regulations. That was the question that we were asking the court to resolve. It does not.
What authority is there for getting that kind of declaration under 906?
Because 906 says the court can resolve an issue, a common question. And that's the common question we're asking the court to resolve. That's, in fact, what the Court of Appeals said in this very case.
Counsel, I've had a lot of your class action motions over the course of years. CPLR 906 is a procedural method. It doesn't provide any substantive remedy. I've never seen a court make a substantive determination as to a class action lawsuit. Then you do discovery, and then after discovery is complete, you come back, and then you make a motion for summary judgment. You turned it on its head. You use the 906 remedy, which is procedural, to bypass or at least to overlook the 3212 motion.
Yeah, so let's be clear that there is almost no case law on 906. This is the only case on 906. So the fact that there's not a lot.
Might be a reason for that.
I think there's a few reasons. The primary one is in New York, you can't get treble damages on a class action. So there isn't a lot of New York jurisprudence on 901 through 909. And I'm
But
sorry.
There's no precedent for using 906 in the way you're trying to do that, is there?
There's no precedent for 906, period. Other
No,
than
there's
that.
no precedent for using 906 in the way you tried to do it, correct? There's
Correct.
precedent for using it to certify a class, but that's not what you're trying to do.
Correct. We're past that.
Thank you.
Okay. But the issue here is,
Can I ask you a simple question? Why don't you just make a motion for summary judgment? Why do you have to go through this whole rigmarole and then say it's this or that? You're saying it's not a summary judgment motion. You usually direct. Why don't you just make the summary judgment motion and tell the court, this is what I want you to do?
it's certainly conceivable that I could do that. The reason we didn't is because we wanted to go to the special referee. We thought rather
Could have
than,
gone to the special referee after the summary judgment motion. Once the liability is had, you know that we can hear and report cases to a referee after the fact. And quite frankly, you've had cases where I've done that.
yeah, and that is, it was just a procedural choice. There wasn't any sort of like hide the
Trying to make
ball.
new law? Is that what you're trying to do?
I'm sorry, say again?
Trying to make new law?
I'm trying to avoid sometimes making new law. It seems like I do it quite a bit. Thank
You
you.
have time on rebuttal.
Good afternoon. Thank you. May it please the court. My name is Matthew Brett. I am the attorney for all of the respondents who are the owners of 11 buildings as part of this class action lawsuit. This seems to be a bit of semantics here because we are in a position, as the court has already acknowledged, that we've never been here before. Article 32, which we all learned in law school, is the dispositive motion practice section of the CPLR. Article 4 has a provision in 409 which allows for determinations on papers, but in the CPLR, those are the only provisions, articles that deal with determinations of liability. And what I believe was happening here, because the court below treated this as a motion for summary judgment, because that's the only remedy that exists in this realm, is that we're looking for a way to avoid proving our case, our prima facie case on a motion for summary judgment. That's what really happened here. It's no attack on my colleague here. It's a creative argument, but it's a way around trying to follow the rules here.
So was he trying to get two bites on the apple? First try 906 and then he do 3212?
Honestly, I don't think he was going to make a 3212 motion because it wouldn't succeed. Just like the court treated it as a 3212 motion, it didn't succeed. And why didn't it succeed? Yes, we can point to the Gray decision, which I was also the attorney on from a couple of days ago. The Gray decision doesn't say that you don't have to put in evidence anymore. What the Gray decision said is that an attorney affirmation can be used to shepherd in some things that are competent evidence. So what was the competent evidence that was put in the motion 906, 3212? It was DHR registrations, a DOB permit, and an incomplete IAI application for a single apartment and an 11-building portfolio with hundreds of apartments with thousands of tenants over decades, okay? There was not a single lease put into evidence. There was not a single document that is for all of the liability.
Counsel, prior to the court converting it to a 3212 motion, was there some sort of notice or opportunity to resubmit papers that should have been given?
There wasn't, but we recognized right away of what it really was.
Well, I understand that because, here we are, but is there a requirement that notice should be given so that the person who is going to be aggrieved by this decision would have had an opportunity to supplement their papers?
I think there probably is such a thing, but at this point in time, we recognize because heretofore there has never been a 906 determination of liability in the state of New York as Justice Hagler pointed out that provision, that the whole article is about procedure, right? It's just a procedural mechanism. If you even read the language of 906, it says nothing about a determination of liability. It just says that the court can make issue classes. So you know, it really doesn't exist. But Your Honor's question, it's a good question. I think it would matter if somebody was misinterpreting what that motion was. We weren't. We recognized what it was. We made clear to the judge that this was a 3212 motion that was really essentially evading the requirements of 3212, which does require a bit more than just an attorney affirmation and 3 documents. If you have
Not necessarily. There are circumstances where a 3212 motion can be made on an attorney affirmation.
Correct, Your Honor, and that would be when there would be documents that were not being contested or evidence that was not contested. And here, when we responded to this, we actually put in all kinds of IAI improvements and other documents that shows. Now, if you have 11 buildings, it's unfathomable to think that you couldn't come up with some tenants or somebody to say, this is the apartment, when I moved in, these IAIs weren't done. I mean, nothing. And if we allow this, we're essentially allowing, it'll be more convenient, but that should not trump the due process rights of a party opposing such a motion. Thank you.
Thank you.
So I do want to note this prima facie burden issue. In rent stabilization, the burden is on the landlord to justify deregulation. The minute I come in with a tenant affidavit saying that these IIs weren't performed, I run smack dab into the Boyd decision from the Court of Appeals that says the tenant affirmation can't challenge IAIs. It's the landlord's burden to put forward the invoices, to put forward the leases.
But you were the one moving for, so to speak, summary judgment. Then you take on certain burdens.
I do take on, if I was moving for summary judgment, which wasn't my intent, and I
Let's
wasn't
just
trying to
make
have 2
believe
bites of
you
the
are
apple.
moving for summary judgment, because you clearly, let's just treat it as the trial court did, as if you were moving for summary judgment.
Okay.
Don't you take on a burden?
If I was moving summary judgment, I do take on a burden. And what I would have done is put forward my same charts and gone through Rule
Counsel,
10.11.
Isn't it an anomaly in a landlord-tenant action, there are no leases put in to make out a prima facie? I've never seen a case in a landlord-tenant context without there being an underlying lease. And quite frankly, you do this all the time, and you always put in the leases. I've never seen a landlord not put in the lease in order to get summary judgment. Can you just answer that question? Why wouldn't you put in
there's
a lease?
there's a little bit of a difference. When you're doing it normally, you're doing it for like 1 person or 2 people or 3 people. We're now doing it for 137 apartments.
You do that all the time. We've seen lots of cases from your office where you do for lots of people at the same time. And I'm not saying that critically, that's helpful.
Right. Okay, so
This isn't an anomaly for you to represent a lot of people at one time.
that's correct. But again, in this particular instance, a lot of material. That's why I used 10.11. Now, and this has been a very insightful conversation as we're trying to map out how we use CPLR 906, because as I said,
We don't. That's the bottom.
I think that
The
is,
bottom line is, I think if you got anything from this conversation, is that we don't.
I think we got that from this
Thank you.
conversation.
Thank
Thank
you
you.
both. Thank you.
Nicely said.
Matter of GA children. Did I skip something? Yeah, that's what I just said. GJ?
Which one is it?
I don't know. GJ. GJ children. Because
Oh, I may have made a mistake.
I see what you're saying, yeah.
Oh, I see.
I see. Okay. We had it as GA, and then some places it's GA, some places it's GJ. That's right. You may proceed.
Good afternoon, Your Honors. May it please the Court, Elizabeth Friedman. I'm appearing for Petitioner Appellant Administration for Children's Services. Your Honor, the Family Court abused its discretion in granting the mother a suspended judgment, providing for dismissal of the petition following 6 months of ACS supervision contingent upon the mother's full compliance.
Family court's reasoning was somewhere along the lines of that the mother was working, it's better for the children, right?
I'm sorry, could you repeat that?
If the mother was working, it's better for the children.
That the mother was working, basically the court did in fact focus on the
Right,
mother.
that was the reasoning behind the family court's suspended judgment.
The reasoning behind
Does that go through the thorough analysis of what is required for a suspended judgment?
Yes, so the analysis, the focus should be on the children's best interests. So determined that should be based upon good cause, which the mother failed to demonstrate. But good cause for suspended judgment, courts consider the following factors: the parent's prior child protective history, if any, the seriousness of the offense, whether the parent has expressed remorse and acknowledged the neglectful nature of their actions, and the parent's amenability to correction, including compliance with court-ordered supervision and treatment.
Do you have to consider all the factors and basically check off each one of them, or is the fact that you fail to meet one or more than one of those factors sufficient to say that she's not entitled to?
Well, Your Honor, I think the factors can be considered together, and I think they can be considered separately as well. And when you don't meet all of the factors, or when you don't properly consider all of the factors, which is what happened here, the family court did not consider all of the factors, although one of the factors was the lack of prior child protective history.
And what about the one about expressing remorse? Because that's one of the things that the court said, she's remorseful. So you have 2 out of 4 right now.
Right. However, if you look at the transcript of the dispositional hearing, the mother failed to demonstrate true remorse and failed to grapple with the seriousness of her conduct. In fact, there were times when she questioned, notwithstanding the fact-finding order that she did not contest, admitting to the allegations set forth in the petition in the fact-finding order, she questioned whether or not the belt had a buckle, whether or not it could have caused the bruise on the child, whether or not perhaps the injury was caused by a toy on his bed. And that was at page 39 of the dispositional hearing on September 4th.
So that you're saying in part that the trial court's finding that she was remorseful was based only on the fact that the mother said, "I'm sorry," but not based on the fact that the mother also said, "Oh, I never used a leather belt. I never hit him with a buckle. I was really just spanking him, and he's exaggerating." So you're saying in part, as I understand it, that the overall tenor of her testimony was not remorseful, even though she said the word remorse once or twice.
I think that is correct, Your Honor. The overall tenor was not remorseful. She never grappled with the seriousness of her conduct. She never acknowledged that it was excessive corporal punishment. And she basically did not. She said, "I am sorry if it caused harm."
If it was intentional, I think she said. If it was intentional. And
If it was intentional.
Or were
if it was.
intentional, I'm sorry.
Basically questioning her son's.
Well, the court also took into consideration that she did, in fact, complete certain programs, right? I think she did 15 sessions of anger management, parenting classes, as well as individual therapy.
Yes, she did testify that she did complete those services, and the court did acknowledge favorably the fact that these programs were completed. However, that doesn't automatically result in a suspended judgment. It doesn't automatically result in dismissal of a petition. There are many reasons why a petition should not be dismissed, and many reasons why a neglect finding should not be dismissed, including future reference in the event the need arises. Certainly, there is hope that there will be no need, but these children are young, and this neglect finding should be on the record. The court did not focus on the best interests of the children before granting a suspended judgment, and which resulted in the supervision for a period, and then stating that it would result in dismissal upon 6 months.
Are you saying that this is premature?
Well, the suspended judgment certainly was premature. It can certainly be sought later, after a certain amount of time. And in fact, the cases that we looked at, we didn't find any cases where the suspended judgment was granted right at disposition. It sometimes happens later, where a parent would move for a suspended judgment.
Thank you. We have time on rebuttal.
Thank you very much.
Good afternoon, Your Honors. Claire Merkin. I'm the attorney for the children in this case. A suspended judgment with a possible vacatur is an extremely rare disposition in Article 10 proceedings. This is because it requires the court to be completely convinced that the parent no longer poses any harm to the child. And so the 4 factors need to be all of them met for a suspended judgment to be given.
All of them.
All of them need to be met. And the one where you see cases focused specifically on is the expression of remorse and acknowledgement of responsibility. So a parent can comply, so all the other factors can be met, but if the parent does not show remorse or acceptance of responsibility, suspended judgments with vacatur are not given. And this is because It's a reflection of future risk. If the parent doesn't acknowledge what they did, doesn't show that they understand what they did wrong, there is a risk that the parent is going to reoffend and commit that conduct. So in all of the cases, this factor has been the most important because it really shows the state of mind of the parent. And in this case, the mother, as Your Honors pointed out, has shown no remorse.
I was just asking a question. I wasn't pointing anything out.
Has shown no remorse for her conduct. She said she only hit the kid with a cloth belt. She denied she caused the injury. She accused
Is there any discretion in that particular factor because the family court's observing the witness and has dealt with the case, or is it so black and white?
So the family court's decision in this case was a little bit bizarre because all of the focus was on the mother. The decision starts with an analysis and focus on the fact that she's been a detective for 25 years. The court went and pulled out news articles that were never in evidence. Nobody introduced it. It has done research to show how the mother has suffered reputational damage from this, how much it's been bad for her. So the decision was really about how awful this has been to the mother. In fact, he doesn't even talk about the allegations in this case. He doesn't talk about the finding in this case. And so the decision reads as an attempt to show why the mother should be getting a suspended judgment, not as an explanation of each of the factors. So the court says she's remorseful, but the quotes even that the court put inside don't show. So for example, they said, "Are you remorseful?" And she said, "Well, I feel bad for how my child feels." She never says, "I feel, this is what I did and I feel bad about it." She was playing with words when it had to do, she was confronted on cross-examination and asked specifically about things. So she was asked, what is your understanding of your finding of the neglect against you? She said it was because of allegations that her son made. And she was asked, well, what is your part in the allegations? And she said, well, corporal punishment. The finding was actually for excessive corporal punishment. You're allowed to use corporal punishment. Then they asked her, well, what did you use? What was the corporal punishment? And she said, the 2 occasions I spanked him with a cloth belt. And then they asked, well, what are the actions you felt remorseful for? And she said, well, using corporal punishment and the way he felt about it.
Can I ask you one other question? The news articles that the court relied on, were any of those offered into evidence at the hearing?
No, the court did its own research. The court did, all of that stuff was not in evidence. And I think
But was referred to by the court?
Yeah.
Yes, okay.
Yeah.
And the consequences to the respondent in this case, the mother, that is not something that the court is to consider at all.
Yes, it is, but it's only one factor. And there are cases, and I cited them in my brief, where the courts have said that the effect on employment is one factor to be considered, but it's not enough when the parent doesn't show remorse. So the fact that it's going to affect your employment, if you have shown no insight or acknowledgement into your conduct, is not going to be a pass out of a neglect finding.
Thank you.
May it please the court, my name is Karen Steinberg and I represent the respondent, Angelica T. This is a case that seems to me is based on semantics.
I don't see that at all. It seems to me that the court never addressed the effect of the mother's behavior, which she had conceded to, on the child, despite the fact that there was evidence of the child's feelings about that. And I didn't see anything about the effect on the child of the mother's conduct in her decision, and therefore no serious consideration of what would be in the child's best interest. So I don't think this is about semantics. I thought it was very much about substance.
Well,
Perhaps you could explain why you see it differently.
Yes, I will. I think that part of the issue here is that the appellants expected her to specifically say, I did these things and I'm sorry. She said she's remorseful. She did parenting classes. She did anger management
classes. But doing
classes.
those things doesn't matter if the person doesn't connect it to their own life. And when she was asked why there was a neglect finding, she said, because my child alleged certain things, not because I hit him with a belt. and it hurt him.
But in her testimony, she talks about what she's learned and how she would deal with things
She
differently.
didn't show that she had applied it to her relationship to her child, at least not, I didn't see anything in her testimony that showed that she connected what she learned to what her behavior was towards her child and the effect on her child.
And the question was asked previously also. I didn't see anything in the decision that talked about the child and the best interest of the child. And in terms of her testimony, I thought it interesting also that the court stated that her testimony was at times evasive and inconsistent, but then went on to credit that testimony. And the decision focused on her responsibilities as a police officer, detective, career advancement, the impact on her employment and career advancement, the fact that she had endured public scrutiny, consequences she was facing in terms of reputational and criminal sanctions, but nothing about the child and what steps she had taken in terms of ensuring that this would not occur again and the child would not be abused, or basically that it was in the best interest of the child for the neglect finding to be vacated.
So yes, I understand what the court is saying, and it's of concern. It was a very strange dispositional hearing. The respondent was called first in the dispositional hearing rather than the petitioner.
Did anyone object to that at the time?
Apparently not, and I concede that. I was not the trial lawyer. I don't know why no one.
ACS has the burden of proof, but they have the right to call the respondent if they.
They didn't call her. They had her she put on her case first, not ACS. So it
No one
wasn't.
object, and she had counsel at that point,
Yes,
right?
she did.
And counsel didn't object.
No, they did
So
not.
that's not preserved.
Right. I'm not, and it wasn't part of my brief. But the issue is that she answered the questions that she was asked. And in part of her testimony on page 25 of the transcript for the hearing, which was September 4th, 2025, she specifically stated that it will never happen again because now I have a different way of seeing things, thinking about discipline. I was raised to believe that physical discipline was a method of discipline that works, but now I no longer feel that way, and I feel it does harm to the child.
Even though she said that, didn't she also say that that the only thing she hit him with was a cloth belt? She didn't acknowledge that she hit him with a buckle or anything heavier than that, and that it happened on many occasions?
In her testimony, she did not acknowledge that she hit him with a belt buckle.
Thank you.
Thank you, Your Honors. Just very briefly, in terms of the mother stating, we do show that she did not show true remorse. And in terms of the mother stating that this would never happen again and she wouldn't do this again, well, she violated the court's prior order in August of 2025 on the visitation. When unsupervised visitation was allowed, she pressured her son to, in fact, talk about the case when she was specifically ordered by the family court not to do so. And that happened, and it required a return to supervised visitation. So she has not shown that she can comply with court orders. She has not shown true remorse. She has not, and in fact, the family court improperly focused on the mother's situation, and she is still employed, of course. She is still employed without focusing on the needs and the best interests of the children here in granting the suspended judgment, and that should be reversed. Thank you.
Thank you. No. Thank you. Thank you all. Ladiri v. Site 6 DSA.
May it please the court, Vincent Chirico for Mr. Lardieri, the plaintiff appellant in this case. Despite the voluminous nature of, or the size of this record, this appeal presents a relatively straightforward single issue. Was plaintiff engaged in a protected activity subject to protection under Labor Law 240.1? Now, my esteemed colleagues on my right will say that plaintiff was only a sales engineer. He didn't even have to be there. He was there only because he was going to a meeting. That contention ignores their own witness's testimony. So we have Mr. Oriema, who's Hunter Roberts' project manager, who says that plaintiff's inspection was crucial to ongoing construction, without which the entire construction project would come to a grinding halt, since Mr. Lardieri was the one responsible for authorizing the startup of these HVAC units. If you didn't start these units, they couldn't get to the next phase of the construction. The People's project manager, Mr. O'Toole, affirms that plaintiff needed to be president so he could authorize the startup of these units. This is fully consistent with plaintiff's own testimony that says this was not the typical sales practice. This was a situation where Hunter Roberts specifically wanted Jill Barr to go into the site and perform the testing of these units on site rather than
So
back
your
at the
client was in
factory.
fact a sales assistant. His duties included entertaining clients, selling the units, visiting the job sites, et cetera, coordinating communication. On the day of the incident, why was he there that day, according to his testimony?
He was there in order to inspect, take photos of the HVAC units, meet with the contractors, and supervise the testing of these units and authorize
Was the testing going
the
to happen that particular day?
I'm sorry?
The testing was happening that day?
That particular day. And it couldn't happen
I thought that day he was there they were going to meet to go over the progress on the unit installation regarding the startup.
they were going to meet, then they were going to perform testing on the units, and it was only Mr. Lardieri who can authorize their startup.
Yes, but your client had no role in physically installing the units. Is that
No,
correct?
and that's correct,
He
Your
had
Honor.
no role in the testing either.
The only role was supervisory at that point, but this,
Why was he necessary?
because it was his say-so to authorize the startup of the units. If he didn't authorize the startup after the testing was done, the construction would not continue.
And this say-so was based on what?
On his testimony, Mr.
No. What would he's gonna state one way or the other whether or not it could begin. What would that be based on?
The testing would have to pass. The troubleshooting of the defects.
He had no technical skills to evaluate that, right?
He didn't, but he had the authority to authorize the startup.
And that would be based on someone else actually doing the testing and then telling him whether or not it was correct or not, and then he would then state whether the project would go forward.
That's correct, Your Honor.
But nothing in terms of his actively engaged in testing.
No, he didn't physically do the work, but
So how would he be covered under the labor law?
because under the precedent of this court and the Court of Appeals, a visual inspection of progress of construction is protected even when it pertains to financial issues. So that is the Desimone case, which held that somebody there to meet with a contractor to go over payroll issues was a protected person under 240. The Melendez case, an inspection integral to the process of the ongoing project. The Campisi case, employees hired to
I'm sorry,
inspect
I'm
the
still
work.
baffled by what technical skills he had.
He doesn't require technical
So
skills.
why would his approval be of any value if he lacks any technical skills related to the machines that they were talking about?
Because if someone told him that the units were functioning properly, he can authorize the startup, then they would start it up. Without his authority
Well, the person who's integral is the person who's doing the inspection to make sure that it's functioning properly.
But that person doesn't have the authority to authorize the startup that day. Only Mr. Lardieri does.
Yeah, and then they will tell him whether everything is fine and therefore to go forward with it. But he has no input. He's, again, as we just stated, he has nothing to do with the testing. And also, you made reference to inspection and that he was there, in a role of inspection. He never said that. He said that he was there to take photographs, and that he doesn't really frame his work as an inspection. And his boss, his supervisor, states that he really wasn't as an inspector.
He wasn't the inspector. He was the person authorized to give the go-ahead.
His company didn't do the actual installation, right?
His company did do the installation. No, his company manufactured the units.
They were salespeople. They sold the units. They didn't do
Right,
the actual
they manufactured and they tested the units.
No, Mammoth, I
No,
think
they
was-
manufactured the units, and the units would then deliver to the site.
Correct.
And then someone else, I forget who, would be the ones who were actually installing the units, right?
There's a difference between installing and testing. Now, normally in the
I
normal
understand
site-
that, but again, the issue is in terms of his responsibilities at the time and whether he is a covered employee under the labor law. You have time on rebuttal.
Thank you.
Could I just ask?
I'm sorry, just go ahead.
What was the, you said there was a site before to his authority to do that. Could you give me that again?
The sites, the DC Moan case, 121.
No. The cites to the record about his having authority, his being the only person who had the authority to start these machines.
Page 1559, that's Frank Oriema's testimony from Hunter Roberts. Mr. O'Toole from Peoples at, I'll get you this site on rebuttal.
And I just want to say, D. Simone, that case involved the on-site project manager who was employed by a contractor and were performing enumerated work. That was not an individual there who was giving the go-ahead, assuming that based upon what someone else or another group was doing in terms of testing.
Well, I would submit that the Reinhardt case also applies here.
Reinhardt v. Long Island Lighting,
Yes, at
plumber employed by plumbing subcontractor.
meeting to discuss a payroll problem.
Plumber, again, by plumber subcontractor.
Yes.
Rebuttal, thank you.
Good afternoon, Your Honors. My name is Peter Simon, and I'm here on behalf of Gilbar. I'm going to waive my oral argument with respect to this issue, but I do reserve my arguments on my appellant issues.
Thank you.
May it please the court, I am Martin Adams, counsel for respondents NYU and Hunter. I respectfully request that both court orders of the trial court be affirmed. With respect to the indemnification, Gilbar is not entitled, appellant Gilbar is not entitled to dismissal of the contractual indemnity claim. The contract at issue refers to the work of Gilbar. It does not specifically limit it to particular aspects of the work. Since the
How many contracts were there, one or two?
There was one contract between Hunter and Gilbar. There was also a purchase order that Gilbar had with Peoples to sell the product, the unit.
The contract referred to these units, or did it refer to something else?
The contract, the Hunter-Gilbar contract, just referred to the work of Gilbar without distinguishing, without limiting, no limitations, just the work. And this accident clearly occurred within the work of Gilbar.
So what was Gilbar supposed to do in terms of its work with respect to these units?
It arranged for the purchase of the units. It sold the units. It was, as Sabara, the president, noted, were basically salesmen. We sold.
So they sold the unit. That's what they did. They sold
Correct.
the unit.
That's
And
right.
plaintiff was your employee, right?
Was Gilbar's?
Plaintiff was Gilbar's employee.
That's correct. Accordingly, I respectfully request that both court orders be affirmed in their entirety. Thank you.
Thank you.
May it please the court, Glenn Kaminsky with the firm Morrow, Lilling Party, counsel for Peoples Mechanical.
Peoples was was responsible for installation, right?
Responsible for the installation of the air handler that was in the mechanical room. Absolutely correct, Your Honor. And we would respectfully ask that the court affirm the decisions below, essentially for the reasons set forth by the court and what's been discussed already. Plaintiff is not a proper labor law defendant here. A plaintiff, excuse me, not a proper labor law plaintiff.
Do you agree with counsel that there was any place in the record where it said that he was essential to start the project?
No, he was absolutely not essential to the work. It is, Mr. Sabera says, he made it clear that the plaintiff had no active role in the construction. He had no responsibility to make final decisions. He was there as a conduit to the final decision makers. He was just a commissioned salesman there in a suit, filling in actually for someone else. That's how unimportant he is to this. His presence wasn't intentional at all. He made it clear that he had no role in starting. Sabaro made it clear he had no role in starting the HVAC unit. He had no expertise, 1233 of the record. Plaintiff did not supervise anything, 1372. Plaintiff did not do any work, 1397. Sabaro said when the unit was finally ready, it would be some outside company that would authorize, that would perform the final task. So plaintiff certainly not entitled to.
What about Peoples and Labor Law 200?
Certainly. The court properly rejected the 200 in the common law claims, the motion by the plaintiff. The case against Peoples is fully premised on nothing but rank speculation. There is no proof whatsoever that Peoples or anyone cut any hanger before the accident.
Wasn't there a People's employee or somebody using People's equipment on
a ladder?
Working near the bracket that somehow fell apart.
Nope. What the testimony is, it is very clear, is that he is working on a fan, and that fan is a standalone device that's not related to the HVAC unit. And what we do know is
what about the pipe? Is it related to the pipe?
It's not related to the pipe. No, the pipe is not Peoples at all, okay? That pipe is Pace's, okay? And the wall that came down with it would be the responsibility of Commodore, which was...
Was there testimony that someone observed someone using a People's ladder doing this particular work?
Right, and we...
This
yes.
injury-producing work?
Not the injury-producing work, no. The testimony was that he was working on a fan that was a standalone...
Well, it was O'Toole said that the worker was using a spackler, but also agreed that it was a People's ladder. But again, People's was responsible for the installation. So we don't know like what occurred at that time with this perhaps a People's worker on the ladder doing whatever they're doing.
No, because what we do know, and there's no dispute about this, is that, and Pace agrees, and Peoples agrees, that the duct work was done before Pace put in the sprinkler pipes. So we're not working where this pipe is because we're done with that ductwork a month before this accident takes place. Yes, we had someone working on a fan. Yes, there was a Commodore, I believe it was a Commodore person doing spackling or something like that. That's not us. All that's true.
But the thing is that person is using a People's ladder, and only People's uses People's ladders, according to People's.
My recollection of the record might be different than yours, Your Honor, and so I might be wrong about this.
Well, I mean, from what I just read, it says that O'Toole stated that the person who was perhaps doing spackling was on a People's ladder.
Yeah, I didn't get that. I know that there was a People's ladder leaning against the HVAC equipment. I know there was a spackling person. My understanding was O'Toole did not equate the two together, but I might be wrong about that, but I don't believe I am.
Someone was on the People's ladder, but thank you.
Thank you very much, Your Honor.
Some people were on People's
Some people on the
The record is clear that Peoples did not allow anyone else to use its ladder. So it had to be someone from Peoples, or it had to be People's subcontractor, if Peoples allowed the subcontractor.
Well, we don't know, but that creates a question of fact.
We don't know. What we do know is you have three different people that say that this hanger was cut.
Really? Three
Yes.
different people?
Mr. Oriema personally observed that the hanger had been cut because it was in someone's way, and they had to move it out of the way and left it inadequately secured. Pace's John Lancelotti saw the cut hangers and confirmed that they were cut and they weren't just torn. Pace's director of fire protection, Peter Mers, said that the hangers had been intentionally cut. So the question on the 200 is people responsible for having created the condition? Mr. Oriema says that that only Peoples or its sub were required to be at that location on the day of the accident, no one else. So it had to have been either Peoples or its sub. So based on that, on the 200, there's at least a question of fact.
So who installed these units? Wasn't it Peoples?
It was Peoples and Mechanical Piping Solutions.
Right, and according to the testimony of Ariema, there was no testing or startup was to occur on the date of the accident, and he says that the plaintiff literally just executes the purchase order and that's it, and he's just a numbers papers guy. That's Oriema's testimony, and I can quote to you the places where it's found in the record. But, you know, given all of that, can we say that he was a protected worker?
Based on the case law and at least plaintiff's own testimony that he had to be there because there was troubleshooting that had to be done and he had to approve that the troubleshooting was there, I would suggest that there's at least an issue of fact on that issue.
Well, counsel, you cited before to page 1559 to show that and based on Mr. Oriema's testimony, and there's nothing there that supports that.
Yeah,
that I could find.
I believe it's 1579, if I'm not mistaken.
While we're waiting, how do you address most of the testimony which refers to the plaintiff as a papers person or a numbers guy? He was wearing a business suit and didn't have any training because
Well, I would suggest that under the case law, he's there performing an investigation. Even if he doesn't himself do it, he's there as part of the ongoing construction work.
even if he's unqualified to do any investigation and has no technical knowledge on the process of starting up an HVAC unit.
He's the supervisor.
He's the
Not the supervisor.
he's not the
But that day he replaced the person whose job it was to supervise and authorize the startup.
He is not directing the installation of
No.
the units.
No, he's directing the testing and the approval.
He isn't even he didn't even testify that he was directing the testing of, he just stated that someone was testing, and then based upon their testing, they would get back to him. He doesn't.
Nor did he say that on page 1579 any more than on 1559.
I could see that. I can't find the page, Your Honor. But I will say that Mr. Lardieri testifies he's scheduled to inspect the installation, take progress photos, and coordinate troubleshooting and repairing a condenser dirty water issue that was delaying the startup process. And Hunter Roberts was concerned that startup would be further delayed. That's at 1615, 1616 of the record.
Thank you.
Thank you.
Did you wish any time to argue?
Good afternoon again. Peter Simon on behalf of Gilbar. I'm going to leave the issues relating to the labor law alone. I'm here to argue about the contractual and common law indemnity. Gilbar is the only party here that is different from everybody else. They're the employer. Everybody concedes that Gilbar performed no work at this site. Therefore, there is no way that Gilbar could have been responsible for, in any way, shape, or form, the fact that these hangers were cut at any point in time. The lower court found, grouped, unfortunately, my client together with Peoples and with the other parties, with Pace, and said someone cut the hanger rods supporting the sprinkler system and no party can identify who did it. Respectfully, the only party that couldn't have done it is Gilbar because everybody concedes that it did no work. With regard to the common law indemnity claims, Gilbar was the employer. They're shielded by workers' comp. They provided workers' comp benefits. There is no grave injury alleged here. Nobody has contested that there is a grave injury. Those claims cannot stand, respectfully. Unless you have any other questions, I'll leave it at that.
Thank you. Thank you all. Zurich American Insurance. Yes.
Okay, good afternoon. May it please the court. Michael Cassell. I represent CJI Northeast. The issue on this appeal is whether or not the court erred in granting summary judgment to 56, the owner essentially, on its contractual indemnification claims. As we set forth in our brief, the key issue here really is this language. It's on page 576 of the record. It's the indemnity provision. And more specifically, it's the language that says basically there's language as to who the indemnities are, and then there's what I refer to as the limiting language, which says basically that my client, CJI, will provide indemnity except to the extent caused by the indemnities, that's EES apostrophe, active negligence or willful misconduct. The lower court, in deciding this as a matter of law, found that that limiting language requires, as a matter of law, that the accident occurred due to the owner's own negligence. As we set forth in our brief, two things that are really important here. One, it's an indemnification provision, must be strictly construed in favor of my client. So if this court finds any ambiguity in this language, it has to be interpreted in my client's favor. Secondly, this was determined as a matter of law on summary judgment. We showed evidence that there's at least a question of fact as to whether Victor Mora's negligence was a factor. And if Victor Mora worked for a company that was affiliated or related to the owner, then therefore there'd be a question of fact as to whether this limiting language is triggered. The lower court, however, solely focused on whether or not there was any active negligence by the owner. We submit that the lower court erred in limiting its interpretation of limiting language, and that there's a question of fact here. Is there any questions?
Whether McGraw was somehow affiliated or related to the owner?
Correct. So the term indemnities is interpreted, I think it's on essentially this fifth or sixth line of the clause, and then it goes on to say, except to the extent caused by the indemnities. So at least, I mean, we are not arguing that the court should find as a matter of law it doesn't apply. It's simply a question of fact. The court misinterpreted the language, and the trier of fact should determine with the proper interpretation whether or not this limiting language applies. Thank you for your time.
Thank you.
Good afternoon, Your Honors. Kevin Wells, the respondent. There was no argument below that McGraw was an indemnity. That was only raised on the appeal. McGraw was the development manager. It's an entity that was hired by my client, the sponsor of the condominium. The development agreement was introduced as part of the supplemental record. It was not part of the motion below because this wasn't argued below. But at appeal, there was an argument that Victor Mora, who's an employee of McGraw, somehow falls within the definition of indemnity because of McGraw's role at the project. But the development manager was not, there's no evidence that they're related or affiliated to the sponsor. They were a hired company to perform.
Who was the sponsor?
56th and Park, New York owner LLC.
And 56 and Park was granted summary judgment?
Summary judgment for contractual indemnification.
Contractual. But 56 and Park is still in as the sponsor?
No, this is, we settled with Zurich, who was the plaintiff. CGI chose not to participate in that settlement, so we brought summary judgment against them for contractual indemnification.
Okay.
So the definition of indemnities is spelled out within the LCA, which is the contract between sponsor and CGI. The indemnities are owner, its related or affiliated companies, subsidiaries, partnerships, joint ventures, shareholders, members, donors, lenders, investors, officers, directors, trustees, employees at every tier, and all their respective heirs, executors, successors, and assigns. Now, developers are not included, agents are not included, contractors are not included. There's no evidence in the record that there's any relationship or affiliation between sponsor and McGraw-Hudson other than we engage them the same way we engage CGI to perform a role in the project. The appellant cites to certain authority that indemnification provisions need to be strictly construed, but then they turn that authority in their head to argue that the definition of indemnity should be interpreted so broadly that
affiliated related companies means any entity with whom we had business dealings. That's not what related or affiliated companies means. We have no business relationship with them. There's no overlap of ownership. There's no control. There's no evidence to that as part of the record. They're insinuating that because we hired them to perform a role on the project, that they somehow fall within this related or affiliated companies definition, and that therefore they're an indemnity under the contract, and then their actions therefore fall within the carve-out. So to get to their argument that they're within the carve-out, you have to read the definition of indemnity so broadly that it's essentially any company that we contract with. Importantly here, during the motion hearing, the appellant was given a chance to point to parts of the record to support their case. They pointed to a few parts, and the motion court asked them about each one, and at each point they conceded that it didn't show that the sponsor had any active negligence or willful misconduct. The last thing I'll mention is that McGraw-Hudson was a separate party in the litigation. They were another defendant, and they didn't argue that they were entitled to contractual indemnification here. It's CGI that has argued that they're within the purview of the definition of indemnities to try to circumvent their contractual obligations.
Counsel, I know I asked you this question again. I want to ask it again. 56 and Park is the owner, and who's the sponsor?
So we're not the owner. We were the sponsor of the condominium. The ownership is transferred to the board of managers of the condominium. So we own the parcel. We engaged parties to construct the building. We then sold the units as a condominium, and ownership is passed to the board of managers and the individual unit owners.
So you're sued in your capacity. You were sued by Zurich in your capacity as the owner. Is that correct?
We were sued by Zurich because we were the party that engaged CGI, and there was no labor law claim or anything like that asserted against us. In this action, they claimed that we were negligent, and we defended that, and we tendered defense to CGI, and they declined.
So in the Supreme Court's decision, when they refer to the sponsor, they're referring to the sponsor as 56 and Park?
Yes, that's my client.
As well as the owner as 56 and Park?
So they use both terms.
Interchangeably, yeah.
The contract between our parties uses the defined term owner.
Yes.
And so they switch back and forth between those two.
So do we ever use the term sponsor? That's used by Supreme Court at one point, right?
I believe it's used in both the transcript and in the decision, yes.
Okay.
But that's referring to my client.
And the name of the LLC is 56 and Park, New York Owner LLC.
Correct. 56 and Park, parentheses, NY, close parentheses, owner, comma, LLC.
Okay.
Thank you.
Just a couple issues on rebuttal. First, as far as the issue about whether or not Mora, who worked for McGraw, was a related or affiliated company, significantly in the decision, the lower court never addressed that. The lower court simply said, no negligence by sponsor, which I acknowledge in going through this brief. I concur with counsel. Sponsor is the same as owner in the indemnity clause is the same as 56 and Park. And lastly, the language says related or affiliated. They acknowledge, meaning 56 and Park, that Mora worked for McGraw, which was an agent. I submit that the term agent at least is related or affiliated, but more importantly, this court doesn't need to decide that issue. I simply argue it should be remanded back to the trier of fact to determine whether or not an agent is related or affiliated. There's a question of fact there. This court does not need to find, as a matter of law, that the agent is a related or affiliated company, simply that there's a question of fact as to that.
So you're saying that the fact that all of these other potential indemnities are stated, subsidiaries, partnerships, joint ventures, is not enough? That they could fall under the category of related or affiliated, even though they're not one of these named here?
I argue that the term agent clearly falls under related or affiliated, but this court nor I need to decide that because really a trier of fact should determine whether or not an agent falls within the scope of the terms related and affiliated. The lower court, however, never decided that issue. Anything else? I appreciate your time. Thank you.
Last case for argument is T-Mobile v. Broadcom. Yes.
May it please the court, my name is Allison Plessman, and I'm here on behalf of Broadcom Inc. and VMware Inc. This case presents a straightforward question. Did the trial court err in granting a mandatory preliminary injunction that granted T-Mobile the full and final relief it sought in the complaint? A year of compelled performance of retired support services, while simultaneously acknowledging that the underlying dispute belongs in arbitration.
When you refer to it as a mandatory injunction, I usually understand a mandatory injunction to mean somebody has to be doing something that they haven't been doing before. But as I understood this injunction, it simply required your client to continue doing what it had been doing. So I'm surprised by your describing it as a mandatory injunction.
Yes, so, and here it's important to look at what is actually required, what Broadcom is actually required to do, and not just the framing of the order.
But it's not required to do something it hadn't already been doing, right?
It is. And that's because in this case, it's not just continuation of the performance of support services that would otherwise continue but for this dispute. In this case, the enterprise order, what sometimes is referred to as the VEO, it's the same thing, expired on August 3rd, 2025. There's no, the provision of support services doesn't just continue without anything else needing to happen. Under the VEO, even if Broadcom hadn't declined to renew, as it's permitted to do under the contract, under the master agreement, a new commercial transaction would need to be entered. It required that T-Mobile pay $5 million for additional renewal services. So a new agreement would have to be reached in order for those additional
So
support services.
your position is that the status quo no longer existed?
Yes, exactly. As of the expiration of the VEO, a new transaction, a new payment for the renewal services would need to be executed and had to be executed as a result of this order. And in addition, in this case, when you think about the status quo, here 2 years ago, in December 2023, Broadcom issued a notice of end of availability for these particular support services. So this was 2 years ago where it sat.
But I understand that in normal circumstances, you would have had a new contract and a payment. But isn't the effect of the contract, of the injunction, that you're providing the services that you were providing before?
Well, I think the concept is, though, however, that
I would like you to answer my question first.
The support services that are ordered to be provided are the support services that they had provided under the VEO, but the VEO expired.
I understand that, thank you.
Were they not negotiating during that time, trying to work out something? Was that not happening?
During the 18 months that T-Mobile waited to file the injunction or the request for the injunction, they were negotiating for some of it. For many, many months, there was no negotiation happening. And undisputed, T-Mobile knew as early as August 2024 that these services would not be renewed. Earlier, really, in December 2023, they could have brought the case in August 2024. This could have been decided on the merits in arbitration with a full evidentiary.
You were negotiating during that time, weren't you?
The parties started negotiating in, I believe, May of 2025. But for months, they had been on notice that Broadcom was not going to renew these services.
Could either party seek legal action? Or was it just something that...
Well, in this case, because Broadcom believed that it was exercising clear rights under the master agreement to not renew the agreement, and that brings me to an important point that I want to highlight because I'm sensitive to running out of time. The entire order and T-Mobile's arguments rest on this mistaken premise that they had an absolute right to renew. And the reason why we get there is because they ignore the second part of the sentence talking about non-cancelable. That sentence in the enterprise order specifically states that the entitlements in the enterprise order are non-cancelable and non-refundable except as expressly permitted by the applicable governing terms. Those applicable governing terms, as expressly stated in the enterprise order, are the master agreement. And if you go to the master agreement, there are specific provisions that allow for cancellation under certain circumstances. One, it allows Broadcom under upon any renewal, to provide notice of its intent not to renew so long as 30 days notice is provided. And it also includes this end of availability provision. So under both of those provisions, those are the exceptions that allow Broadcom to cancel the contract, cancel that entitlement to the renewal right. The trial court didn't grapple with that second half of the sentence at all. And T-Mobile doesn't at all either. And that's a critical omission in the ruling, because that, except as expressly permitted by the applicable governing terms, is what gives Broadcom the right to do that, the right to cancel this entitlement under those circumstances. And there's no real dispute that the notice of end availability was given in December 2023, and they knew no later than August 2024 that Broadcom was not going to renew these support services.
So you're basically saying there was no likelihood of success on the merits for this preliminary injunction?
Exactly.
Thank you.
May it please the court, Larry Heffman on behalf of T-Mobile. The trial court appropriately exercised its discretion and granted a preliminary injunction to prevent irreparable harm to T-Mobile from Broadcom prematurely cutting off services to which T-Mobile was
Is
entitled.
it going to be prematurely or at the end of the contract, at the end of the agreement?
The contract didn't end, Your Honor, until August of 2026 because T-Mobile had the express right to extend that contract by 1 year by paying $5.288 million. The enterprise order, which is the prevailing agreement, is very straightforward.
When did that agreement expire, the enterprise agreement?
So, Your Honor, the agreement was signed in August of 2023. It had an initial 2-year term, and then it said T-Mobile had the ability, and the only condition to T-Mobile extending the contract for a year was T-Mobile pays the money. T-Mobile paid the money before August of 2025, which is when that initial 2-year term expired. And what Justice Schechter appropriately recognized is that language is plain as day. It has no conditions. It gives T-Mobile the option to pay and get the services, and it doesn't condition it on Broadcom doing anything. It's an agreement that we reached in 2023. Broadcom's whole argument is, I want to non-renew this agreement. Well, you already sold it. We already bought that right. You can't non-renew it 2 years after we already had a deal where we gave up certain rights, where we agreed to certain terms. And I want to emphasize for the court.
And was Broadcom succeeded to VMware's interests at the time you signed the 2023 contract?
No, Your Honor. Broadcom bought VMware for...
So they bought subject to the contract?
They bought it subject to the contract. And what this case is really about is Broadcom paid $69 billion for VMware. And they want to take other services and package them together. And they want to get out of their existing contractual rights. And they are using anything they can to try to get out of the plain language of this contract. And Justice Schechter said, there is a clear likelihood of success. This is the second time she's rejected this argument. When AT&T sued in 2024, she ruled in favor of AT&T on a preliminary injunction.
Type of contract?
Same type of contract, same exact issue, Your Honor. And she ruled the exact same way. That transcript is in the record. And when Ms. Plessman appeared before her for this oral argument, she said, this isn't the first time we're seeing each other. And she said, this case is even stronger because we have an enterprise order, a brief, very simple contract that says T-Mobile can pay and it gets the services. It also says the enterprise order is the prevailing agreement. So if anybody wants to say that there's something that conflicts with T-Mobile's rights in this contract, the enterprise order prevails.
So you already paid the $5 million to allow you to continue receiving the services through 2026?
Yes, Your Honor. And just to clarify that, we said we're ready, willing, and able to pay months before August of 2025. They refused. And then after Justice Schechter ordered the injunction, and during the injunction hearing, she said, you're going to pay the $5.2 million. And we said, absolutely, and we have paid that. And we sent a wire and to Broadcom with that, I think a check and then a wire, Your Honor. So they have the money, we paid. And all we're doing is holding Broadcom to the deal that they agreed to. And they characterized, go ahead, Your Honor.
Oh, finish your sentence.
Okay. They characterized that in their briefs as forced servitude. And Justice Schechter rightly said, this isn't forced servitude. This is holding you to a deal with no prejudice to them because they're receiving $5.288 million for services that they are continuing to provide to many other customers who had longer deals. And I want to emphasize...
Now, Okay. What
Please
was
go
your
ahead, John.
position as to the amount of the undertaking for the injunction?
Your Honor, so what we said initially was there shouldn't be an undertaking because the contract waives it. Justice Schechter said the law requires an undertaking. Then I said, well, it could be the contract amount, but then as the argument evolved, she said, are you going to pay the contract amount? And we said, yes, okay? Then she went to Broadcom and said, what's the basis of any damages? And if you look at their declaration, they don't have any damages. They don't have they're getting $5.25 million to perform the services. Their declaration doesn't say that they paid 1 cent more to an employee, that they had to hire a contractor. It's because they're not standing up some new software team. They're just doing what they
Counsel,
were
what
already
was the
doing.
basis of the $500,000 undertaking?
Your Honor, the court didn't specify the basis of the $500,000. That specific amount was not discussed at the hearing. But I think this court can look at the context and can evaluate, did Broadcom articulate damages? Did they explain and provide an affidavit saying, I am going to suffer damages and in what amount? And their declaration is a very grand declaration, Your Honor, that says it's going to inhibit their transition to a new enterprise. But basically, they have no damages. I think the court put in a prophylactic amount of $500,000, given the magnitude of the contract, but did not specify the precise reasons.
Thank you.
Thank you, Your Honors.
Yes, thank you. So again, counsel completely ignores the second part of the sentence in the VEO, in the enterprise order, that says it's non-cancelable except as expressly permitted in the master services agreement, and the master services agreement expressly includes cancellation provisions, which Broadcom followed.
Under what terms?
I'm sorry, under
What were the terms of that
the terms of the...
that permitted the cancellation?
Oh, so there's two. The first one, there's a non-renewal provision in the master agreement that says upon any renewal, any party can issue a notice of its intent not to renew so long as it provides 30 days written notice, which was done. It also allows the discontinuation of support services upon end of availability of software or support services, which again was done. It was announced in December 2023. Those are two express provisions in the master services agreement that allow for non-renewal in this case. And the trial court never grappled with it, and again, counsel doesn't grapple with it again. Now, with respect to the undertaking, I want to address that quickly. There is no support for the $500,000. Counsel for T-Mobile itself.
Is there support for anything? What did you put forward?
So in the
put forth in terms of what the undertaking should be?
Yes, so in the Walter affirmation, it details Broadcom's damages in detail, the types of damages that it will incur, and it also talks a lot about the fair market value.
Did it then specify an amount of undertaking in the event that the court chose to issue a preliminary injunction?
Yes, it requested $20 million because that was the offer that T-Mobile made for the support services that it is now demanding that it receive. And so that was the last offer before it filed its motion for injunction. That was their valuation of what they were going to receive, was $20 million. And that's in our declaration, that's in the Walter affirmation. None of that was rebutted. None of the damages were rebutted. And so that, what the court had before it was either $5 million presented by counsel or $20 million presented by us, and then we got $500,000. And she ordered final relief through August 3rd, 2026, with this nominal $500,000 bond. So we're stuck in a situation of arbitrating, probably spending more than $500,000 to get to a hearing in September of 2026 when the hearing has been ordered, and they will have received all of the support services to which they claim they're entitled, even though the master services agreement includes these express provisions saying cancellation is entitled.
Preliminary injunction expire by its terms on August 3rd, 26?
Yes, and that was all that was requested in the complaint. That was the final relief requested. So the court, unlike the AT&T case where the court specifically said, I am not going to enjoin for the full amount, you guys should talk about it, an injunction wasn't ever issued because the parties came to a settlement and it was voluntarily dismissed with prejudice. So because the court indicated, I'm not going to do the final relief thing that she did here in this case, and that's what's so especially problematic because they're getting all of the relief sought in the complaint before there's even going to be a hearing in arbitration in September of 2026.
Thank you. Thank you all.
cleared out the court. Nice to meet you in person. I always forget that I have a team.
David Kim. Nice to meet you.